of work for the Joint Judiciary Committee. We have a number of guests with us here today and would like to honor and respect their presence here. We have the good Representative Jim Blackburn joining us here, a Laramie County legislator. I know he asked me not to do that, and so of course I did. And then Representative Pat Sweeney from Natrona County joining us as well, and Representative Kathy Connolly too from Albany County. Thanks for joining with us today and increasing the room. And we have former Representative Sarah Burlingame also joining Representative Blackburn at the front here. It is a lot of House members, but we are grateful to have you here today. So with that, we'll start our afternoon. A quick reminder for those intending to provide public comment, there is a sign-up sheet outside with all of our meeting materials. If you could sign up there, and I'll remind you to do this again later, but it would be very helpful if you did sign in that sign-in sheet so we could keep accurate minutes for our staff, so we can make sure we have a correct record. So please be sure to do that sign-in sheet. And with that, we'll go ahead and start with LSO, going over our bill drafts for bias-motivated crimes. Mr. Fuller.
Thank you, Madam Chairman. I'll start with 22 LSO 119, discrimination prohibition amendments. And the committee should have received also some separate information from me just regarding the background of the 5 classes that are protected in the Civil Rights Act, the Federal Civil Rights Act, and then the use of the terms creed versus religion in our statutes. They appear to be used separately. There was only one place in which both terms appeared, and that was a statute concerning charter schools. And I think the question there would be, whether that statute needed both the inclusion of both terms in light of, say, certain federal requirements that may be associated with education. The footnotes that I provided list all of the statutes and references, but the Wyoming Supreme Court, in short, is basically, it appears they've considered the word creed to mean religion, and they've referenced religious creed in a case involving a wrongful termination. So with that, unless there's any questions about that, I'll just proceed to the bill draft. And there's a couple different ways, and it should be draft point 3, 22 LSO 119. And there's a couple different ways the committee could approach this. All this draft does is simply insert the word religion into the classes of discrimination that are prohibited in 69102. And the committee could replace the word creed with religion. It could use religious creed in light of the Supreme Court case. I think that's a decision for the committee to make. And then the staff comment just also notes that there was discussion at the last meeting regarding disability and the question whether the committee would want to consider its inclusion in this 69102. With that, Madam Chairman, members of the committee, I'll stand for questions on this bill draft.
Questions for Mr. Fuller? All right, seeing none. Thank you, Mr. Fuller. Would you like to go to do working draft 120 as well, version 0.4?
Madam Chairman, I can if it's
let's do that.
The will of the committee. Sure. So this bill draft, this is working draft 0.4, 22 LSO 120. And this bill draft would require the Division of Criminal Investigation to collect and report statistics concerning crimes that exhibit evidence of prejudice based on specific categories. And the language that is used in this draft is based on language from Utah law, which was discussed at the committee's June meeting. So starting on page 2, lines 10 to 13, this is an amendment to 71102, which concerns requirements for maintaining a public record of crime and criminals in the state. And the addition to this section would require that the uniform forms that are prepared and provided by the Attorney General, they must ensure that the data and information concerning crimes that exhibit evidence of prejudice based on categories that I'll discuss a bit later can be reported. Then moving on to page 3, this is the substantive part of the bill that imposes these duties on the division. Lines 15 to 17 would require DCI to, as part of the annual report on crime statistics, they must include in that report statistics concerning crimes that exhibit evidence of prejudice based on the categories that are listed on lines 21 and 22. And those categories are based on what's in Utah law. And so it doesn't track the Civil Rights Act, but just as a placeholder for the committee, those categories come directly from Utah's law. And with that, Madam Chairman, members of the committee, I'm happy to answer questions.
Questions for Mr. Fuller? You had a good lunch, I can tell. All right. Thank you, Mr. Fuller. I appreciate those explanations. Committee will go ahead and go back to working draft 22 LSO 119 version 0.3. This is where the committee is adding the word religion to Wyoming statute 69102. There is a staff comment there. Any discussion on the bill or staff comment on this that you'd like to address right now? Do we have any public comment on this bill? Ms. Chambers?
Good afternoon. My name is Kara Chambers. I'm with the Wyoming Attorney General's Office today, speaking on behalf of DCI, the Division of Criminal Investigation. Well, maybe you will tell me how you would like this to proceed, because we've talked about a couple things, and I'm prepared to talk about reporting with the second bill, but with this one, because it ties into how we report onto crime, I would like to make a suggestion for some language, if that's at all possible. With the existing bill, well, quite frankly, I'll start at the beginning on page 1, line 11 of 69102. And it has, this original statute was drafted sometime in the 50s, if I'm correct. And we have some sort of archaic language. And being someone in victim services, which is my main hat, I'm not sure how I respond to someone denied the right to life. Well, life is pretty self-explanatory, but liberty, the pursuit of happiness, or the necessities of life. What bias or discrimination, I was just wondering if the committee has thought of maybe zhuzhing up the language to maybe be more modern. I do not have specific suggestions. My specific suggestion is actually on page 2, line 1, and it would begin after because of, strike the remainder of that line and line 2 and insert, well, I guess we'd have to finesse this a bit, but what I'd like to do is cite the federal statute, which is 18 US Code section 249. And that way, if anything ever changes, we don't have to mess with this. We don't need to debate the staff comment on creed versus religion. It would just be all encompassed under the federal hate crime law. And so I wanted to present that to the committee, if that makes sense. I can go on.
Any questions of Ms. Chambers about that proposal? Representative Yin?
Thank you, Madam Chair. So is it, so you were saying that this law ties into the hate reporting. Is it because that there's inconsistency with, if you wanted to report into a federal database, there's inconsistency between the federal database and this hate crime statute?
Madam Chair.
Ms. Chambers?
Representative Yin, yes. And so when we get into draft 120, which is really the DCI's purview of the AG must develop a form to report on this, yes, it would make it match uniformly, and I'll be presenting a similar recommendation for that bill draft, to just strike all the various categories, insert the federal statute that encompasses that, to make it cleaner, less need for change, and absolutely makes our job a lot easier.
And Google. Mr. Co-Chairman?
Thank you, Madam Co-Chairman. I think I found it. I was looking at the code
249.
and trying to understand if it actually included gender. I think maybe that's to your point, because it looks like that was probably later amended in, but it looks like it is in section 2.
A2.
Because you're using the entire statute.
Yeah,
Okay.
using it, referencing the entire section.
All right.
Any further questions from the committee? Ms. Chambers, you have more comments on the bill?
I did have a little bit of comment, which is actually outside of the draft because I noticed that nothing was done to section 101 of this statute. And I would suggest that perhaps conforming amendments, but I also, again, my kind of concern with old language that I don't know what a person of good deportment is per se. And I would hate for someone of poor deportment to be denied benefits of the law. So those are just some things that kind of struck my office.
That's a
And-
fair point. Committee members of good deportment, any comments or questions to Ms. Chambers?
Madam Chairman, in case the other members don't have the statute pulled up, would you like me to read 69101?
Sure.
Yeah, I
That
have it
works.
as well.
So on 69101, it's all persons of good deportment are entitled to the full and equal enjoyment of all accommodations, advantages, facilities, and privileges of all places or agencies which are public in nature, of which invite the patronage of the public without any distinction, discrimination, or restriction on account of race, religion, color, sex, or national origin.
Which of course I would suggest inserting 18 USC 249.
So long as they're of good deportment.
As only, yes, ma'am.
I need to look up deportment. All right. Further discussion from the committee? Questions for Ms. Chambers? A round of jumping jacks, maybe? All right. Any further comments on this bill draft, Ms. Chambers?
No, Madam Chair. I did some statistical research on it and I thought it was interesting to note because again, I don't know if this is the appropriate time, but I was also tasked by you with looking into alternatives to reporting these type of incidences outside of a law enforcement venue. And I worked with Representative Provenza on that briefly, and I've worked with former Representative Burlingame, who's here in attendance. And I don't know if you want to discuss that now or at another time or what that looks like.
Since you're at the mic, we'll go
Yeah.
ahead and have you speak with us about that.
Madam Chair, so that sort of relates back to my comment of this whole life, liberty, pursuit of happiness, and the necessities of life. What I did do is I went back and the most recent FBI stats on bias motivated crimes were actually the 2019 report. And the majority of bias incidents were actually on the basis of race, which was interesting. I would argue that other categories that may be included may have some chilling effect to reporting, which is sort of in line with what we're talking about. So take that as it were. And then within that category, the most instances were actually crimes against property, destruction, damage, and vandalism. So I thought that was interesting. And how that ties into what I would like to discuss as far as creating an alternative mechanism to reporting outside of law enforcement is, in my world, being victim services, we have distinct entry points into our world, whether it is criminal justice, and our alternative mechanism is usually through a hospital. So if a victim is physically injured, they can seek services through a hospital, or sexually assaulted is actually the paradigm that we use. And they can report to a medical facility and obtain, at no charge to them, a sexual assault exam. And that is for the purpose of evidence collection. And so that will be collected and preserved because we understand that there's a criminal justice reason for that. But then the victim can make a decision of whether or not they want to report that crime to law enforcement. But we'll preserve the evidence, let the victim make their own determination on how they'd like to see this matter move forward. But my division will pay for those kits. And then we, of course, make sure that the victim is apprised of whatever other advocacy that services might be available to them through nonprofit programs that is also funded across the state through the Division of Victim Services. So I think that mechanism would certainly carry over for biased crime victims who had a physical injury. But being that most of the biased crimes reported are these property or destruction, I don't know what the point of entry would be short of a hotline. Now, the FBI does have a national hotline for biased crime reporting, but the FBI is a law enforcement agency. So I don't know if that exactly comports with what what we were thinking about. And I think you and I discussed this, Representative Provenza, but I just wanted to bring that to light. I do think there's a need. I do think there's probably certain types of victims of bias crimes who are reluctant to report to law enforcement. And I acknowledge that, but I am struggling with an entry point into victim services for those victims, depending on the type of crime that's committed against them.
All right, thank you.
Yes.
Any questions for Ms. Chambers about that follow-up? Appreciate the efforts there.
Beyond that, if you want to move to the other draft or hear from other folks, I will.
Let's go ahead and hear from other folks on this bill draft. I think most people are here substantively on the reporting bill. And so that's kind of where everyone is going. But for now, in order for the committee to kind of manage all of it in a methodical way, we'll just keep focused on the first bill draft for our consideration, which is point 3. So any further public comment on discrimination prohibition amendments? Representative Connolly.
Thank you, Madam Chairman, members of the committee. I'm glad to be here today. Thanks for taking up this issue and taking it up in the interim. I just wanted to remind us for a second how we got here. And it's honestly the notion that we're the equality state, that we want to be a welcoming state, and we in no way tolerate discrimination. And that's kind of the highest level of how we got here today. And that being the case, we turn to our Constitution and our statutes, and in this case, our statute, where words matter. Now, I must admit, I've been having fun thinking to my head about good deportment, but we're not going to go there. But we are going to go to the other element of 22 LSO 119, which are the categories that are listed on page 2. And the purpose of us looking at this bill and expanding it to include religion to start with was to be more inclusive. Those words matter. Our citizens and our practitioners, they turn to our statutes. They want to know what they say. They want to know what they mean. And in all honesty, what we mean, I think, is exactly what Ms. Chambers, through the Attorney General, was talking about. What we mean is 18 U.S.C. 249. So I would very much encourage us to make this bill meaningful. We need to include the categories and their interpretation that are included in 18 U.S.C. 249. So I would encourage the committee to adopt that amendment to make this bill meaningful. And then honestly, with the reporting bill, to do the same thing. Thank you, Madam Chair.
Thank you, Representative. Questions for Representative Connolly? Appreciate seeing you today.
Same here.
All right, any further public comment on this bill draft?
Madam Chairman,
Yes.
we do have one person on Zoom with their hand raised. It looks like we have a Roland Wong with the OCA Asian Pacific American Advocates.
Wonderful. Let's invite him in.
All right, he's in and just needs to turn his camera and microphone on.
Thank you to the Joint Judiciary Committee for allowing me to speak. I am Roland Wong, Vice President for Public Affairs of the organization OCA, Asian Pacific American Advocates. OCA is a national organization engaged in civil rights advocacy with its national office in Washington, D.C., and with 50 chapters across the country. I just want to mention that crime data needs to be specific and disaggregated to be useful. It's one thing to say that crime generally in broad categories is up or down. Crime statistics are not uniform across the country. And so different states, different communities, different racial groups, city, suburban, rural communities, and socioeconomic status all affect crime reporting. And so it's important that Wyoming, as a major state, consider having a hate crime reporting statute, much like the rest of the states of this union. Hate crime reporting is not consistent based upon the 1990 Hate Crime Statistics Act. Many states struggle with the uniformity of the reporting and police reports and data collection. And so compliance has been spotty. In the current situation, anti-Asian violence and anti-Semitic hate incidents have spiked in the last year and a half. And it's really time to take notice of the change in statistics. And that's best done by having, uniform state to state, crime statistics and reporting. So that is sort of the request. Underreporting is suspected. And so states like Wyoming should adopt a hate crimes reporting act that fosters the proper and accurate reporting of hate crimes. Wyoming is just part of the puzzle of understanding the hate crime statistics, coast to coast and state to state. I should note that the FBI data for Wyoming reports hate crimes based upon race and ethnicity being just one case in 2017, 0 cases in 2018, 4 cases in 2019. And so that reflects a 400% increase in 2019 over 2017. Based upon religion, there was just 1 case reported in 2017 to the FBI. For sexual orientation, there were 2 cases in 2017, 1 case in 2019. 0 cases across the board for disability, 0 cases based upon gender, and 0 cases for each year based upon gender identity. But I suspect that in large part, this is due to underreporting. So I think it's really time for Wyoming to address a hate crimes statistics and reporting statute so that we get a more complete picture of what hate crimes have occurred in Wyoming as part of that overall national picture. So thank you very much.
Thank you, Mr. Huang. Are there any questions? We appreciate hearing from you and being here today. Thank you for your testimony.
Thank you.
All right, is there anyone else on Zoom? I don't think so. Further public comment on this bill, Ms. King?
Thank you, Madam Co-Chair and members of the committee. Sabrina King with the ACLU of Wyoming. Just a very brief comment on this particular draft piece of legislation. We support the proposed changes that have been brought forward. I think in particular, looking at both 69101 and 69102, they do a little bit go as a pair, and there may be some anachronistic language that also needs to be changed in 101. But we would also say that if we're looking at that collection of statutes, 69103 is a $100 fine for charging someone for use of a public bathroom, which I think is also an anachronism of the 1950s and could probably go away. So as long as we're looking at that statute and looking at potential updates, we would recommend just maybe getting rid of that. But otherwise, support the proposed changes and including the language that has been given by Ms. Chambers and Representative Connolly. So thank you.
Thank you, Ms. King. Any questions for Ms. King? Appreciate it. Thank you. Anyone else would like to comment on this bill draft? There's a debate. Please come forward.
Thank you, Madam Chairwoman. Thank you, committee. It's a pleasure to be in front of you today. I'm Sarah Burlingame, and I'm the Director of Wyoming Equality. And I come in front of you today to support this bill and also to support the inclusion of including 18 U.S. Code Section 249. Just briefly, if folks don't know how often my organization, the nonprofit Wyoming Equality, we do statewide LGBTQ advocacy. And I think most folks might assume that we have little to no contact or relationship with law enforcement, but the opposite is actually true. And when Cheyenne just recently got a new police chief, one of the first things he did was, reach out so that we could sit down and have lunch together, because we wanted to be sure that we were on the same page. And we have questions for law enforcement just the same way that law enforcement has questions for us. And what they all revolve around is something that the gentleman from the Pacific Island Institute just mentioned, which was that struggle for uniformity, is saying, I know what I mean when I say protected classes, but I don't know what you mean. I don't know if Albany County uses the same metric that Laramie County does. And bias crimes are not different from any other issue that we face in Wyoming, where we have different counties who have different standards, we have different metrics. And the job of the legislature, right? The job of the statewide agency is to say, how can we bring us into harmony? How can we make the job easier and not harder for law enforcement? And I'm just going to suggest that if we have a patchwork of definitions, if Albany County is significantly different from Laramie County, then we're making it harder for law enforcement to do their jobs, and we're putting a burden on them. I can't even get into comportment. I don't know how we're going to ask law enforcement to say, no, their comportment was pretty good. Their comportment was lacking. But I am going to point out that, the signature event that Wyoming Equality does is an event called Rendezvous. And it's a camp out in the woods. And we canceled it last year for COVID. We thought we were going to cancel it this year. We thought just a handful of folks would come. We ended up having 350 people come to the Medicine Bow National Forest. And on the very first day that everyone was together, we had the occasion to call law enforcement. We had to call law enforcement because there was a little 7-year-old boy who'd been abandoned, and he'd spent the night out alone. And he didn't have clothes. He was out in the elements, and these 3 men found him. And ordinarily, you would just think they're heroes, right? Like, they found this young man. I don't know that he would have survived another night outside. Of course, they call law enforcement. Of course, they have no question but being told, thank you. Thank you for offering this service. But they're gay men in the middle of Wyoming. And their first concern was, what law enforcement is going to come? How will I be received? It turns out that we were on the Albany County side of the line, and the Albany County sheriffs came out. They could not have been more professional. They could not have been more understanding. They could not have done a more professional job in handling it. But the fact was that those men had terror over doing a good deed, a great deed. And it shouldn't be like that, right? Like, we should have uniformity. We should be all confident that our taxpayer dollars are going to pay agencies that will support us and not parse out which part of our humanity, which part of our identity is acceptable or not. That one had a happy ending. I think this body has done such good work in getting us closer to a place where our law enforcement can say, whether you're in Albany County or Teton County or Johnson County, what does it say? It says 18 US Code Section 249. We match. That's it. It solves the struggle of uniformity. I urge you all to bring and accept this amendment, and I'd stand for any questions.
Thank you, Ms. Burlingame. Representative Rodriguez-Williams.
Thank you, Madam Chairman. Thank you, Ms. Burlingame. Quick question. You mentioned that passing this bill would make law enforcement's job easier through uniformity. Can you tell me how many agencies throughout the state of Wyoming you've spoken with? Thank you.
Ms. Burlingame.
Madam Chairwoman, sure. I've had conversations with our local police chief here who was in support of it. I've spoken, I've spoken with Byron Odekoven, and I believe that the U.S., or not the U.S., rather the Wyoming sheriffs and chiefs, he's not here today, but I'm happy to follow up with him. I'm real chatty. So when I run across law enforcement, I say, hey, I'm Sarah Burlingame. Do you have a minute? I'd love to talk to you about bias crimes. I've not run across anyone who in law enforcement certainly not from the federal, state, or local, who has objected to it. And if you have, I'd love to hear what their concerns were, because I certainly haven't heard them.
All right, further questions for Ms. Burlingame? All right, seeing none. Thank you, Ms. Burlingame. Appreciate seeing
Thank you,
you.
Madam Chairman.
Further comments on the bill? Ms. Chambers, please come forward. You think you can speaking?
I just have a.
Co-Chairman
question for
Olson
you.
would like to ask you a question.
I mean, I know the answer, but because it's being
Well, then
fleshed
this will
out,
be
I think
fun.
I know the answer, but I think it needs to be fleshed out in the record, since now we're talking about this 18 USC 249. So I just wanted your opinion, because this is a federal hate crime statute that
The 18,
already
yeah.
exists. So I guess my question is, what types of hate crimes would we be covering in the state that wouldn't be covered by the federal statute?
Madam Chair. Co-Chairman Olson, you're asking me if the state would have categories outside of what's under section 249? No, I misunderstood
There
then.
is so 18 USC 249 federal hate crime statute
Yes.
applies to citizens inside the state of Wyoming.
Correct.
Not all cases. So that's my question really. What does any change to our state statute provide in terms of protection for Wyoming citizens that the federal statute for hate crimes wouldn't offer?
I
Does
see.
that make sense?
Madam Chair. Co-Chairman Olson. Well, I mean, please don't make me give you the whole like 10th Amendment, the separation of federal and state and whatnot. State statutes can always be more protective than the federal law. I think what you're trying to do here is bring some uniformity to the state level. I mean, let's acknowledge first and foremost that one of the reasons this bill is being championed is because we have been on a perceived naughty list for some time as being one of now maybe only 2 states without recognized hate crime laws. And so one of the things that you're trying to do here is make sure that Wyoming is acknowledged to have a state statute that addresses hate crime laws. So yes, they are inclusive, and there's many cases, depending on the circumstances of the case, that would perhaps go to a federal court instead of a state court. But this is similar to when we passed human trafficking legislation. Of course, there's been a federal crime against human trafficking since 2001, but it wasn't until 2013 that this body adopted state level legislation. In the event that there are some cases that aren't able to go to the federal level, we acknowledged that the state of Wyoming also feels that this is an important value and that this is a crime that's acknowledged within the borders of our state. And so that's usually the need or the desire to have those sort of mirror statutes. But yes, you're correct. It is very similar. And again, depending on the elements of the crime, a lot of acts that may happen in our state, especially considering we have a lot of federal land and a large landmass reservation, that these would go federal. But I do think this body has indicated that it's important to have state level legislation as well. I hope that answered your question. I think I'm struggling if there's some, if the question was, are there things that might go under federal that wouldn't go under state? The statute that you have that you're trying to amend, which I've also made some suggestions to maybe expand to, 69101 and 102, and I don't want to have to pay for bathrooms, so we maybe should look at 103. Or trying to signal something. And again, when I mentioned those very broad categories of life, liberty, the pursuit of happiness, and the necessities of life, if you could tell me what that encompasses, that'd be great.
Ms. Chambers, maybe to help, and I think you did answer Co-Chairman Olson's question, but just maybe more clearly, I'll just ask this. Can state prosecutors or county prosecutors prosecute federal crimes?
Madam Chairman, they cannot.
Okay, thank you. All right, further questions for Ms. Chambers? Representative Zwanitzer.
Thank you, Madam Chairman. Would it be correct that the perhaps biggest difference between our state statute and the federal 18 U.S. Code 249 is they actually use the language because of actual or perceived race, color, religion, or national origin. And so you actually under Wyoming have to prove it was, I don't know, I don't think anyone actually uses our statute or has used. Maybe that'd be another great question. Do you know of anyone ever being charged under the current statute of
69101.
69102? That's my first question. But my second big difference where we are from other states is in this perceived, that you would actually have to prove that they knew exactly what race or religion or national origin instead of it being perceived. And is there a difference in your mind if that's a big gap right now in our laws?
Ms. Chambers, I think your request has been confused, your proposed amendment to an adoption of the federal hate crime law as opposed to adopting the definitions as found in the federal hate crime law. And so we're going to need to make sure that's very clear that your proposed amendment is not to dispel of our discrimination associated with public accommodations and associated penalties, is simply to adopt the federal definitions. And I'm guessing and sensing due to the excitement and concern and anxiety over this bill and the topic it's presented, there's a lot of conflation of issues happening, also concerning the hate crime reporting concept. So let's take a deep breath in and a deep breath out. And we'll just focus on the bill in front of us right here. And the current proposal is to fix the definitions from what has been historically in place found on page 2, lines 1 and 2, that says race, color, sex, creed, our bill draft, religion, or national origin. The request from, I think, the public comment and from Ms. Chambers is to replace that definition with the definition as found in 18 USC 249, which happens to be the hate crime legislation. It's an interesting proposal to go with the federal hate crime law as opposed to the Civil Rights Act and those changes there. And so that's, I also think, probably creating some confusion amongst the committee members. So hopefully that helps to clarify it, and you can provide some clarifying comments, and anyone else that would like to provide additional clarifying comments. If I've misunderstood that, please feel free to correct me, but that's where I think where we are. Is that correct?
Madam Chair, yes. I was wondering if there's going to be a question at the end. Yes, that is correct.
Well, I just want to make sure we don't start
No,
going down a question of adopting federal hate crime laws.
No, and thank you for that clarification. Yes, I'm suggesting we use those definitions because when we get into, just as you've said, Madam Chair, when we get into draft 120, we need to make sure that we're reporting that the definitions that we're using comport with the reporting mechanism that DCI uses, which is the NIBR system that is predicated on federal definitions.
So we are working on 22 LSO 119 working draft point 3. It is not the reporting bill. Not the reporting bill. We are working on our public accommodation and discrimination bill, which is kind of this old antiquated concept, you know, that is in a statutory section consistent with these other kind of antiquated concepts as well. And the question is, should we update those definitions associated with that or not? And what type of definitions should we include? That's the question. Nothing to do with reporting. Senator Kolb?
Thank you, co-chair. Particularly with the religion, I guess I'm a little bit squishy on why it was necessary to insert. Is it possibly, would it be the evolution of English and us not using, creed in the same way? Or what is, because I see creed, if you read the definitions, I kind of like English, and I read, it seems like it's appropriate. So I just wondered if you could maybe enlighten me, help me out a little bit. Thank you.
Ms. Chambers?
Madam Chair, Senator Kolb, I would agree. As we've talked about some of, that we keep harping back on the good deportment. This was older language. I do believe, and again, I am not a scholar of the English language per se, but I do believe they were used interchangeably, which is sort of goes back to why I'm suggesting just use the federal definitions, because it's just very clean. They don't use creed anymore. They use religion. I believe Ms. Burlingame actually had done some research on it, and creed was meant to encompass slightly more than recognized organized religion. But getting aside from that, the federal definition of religion is fairly well defined and what those sort of biases cover. But again, my suggestion, just to make it cleaner so that we don't have debates. I do know that LSO was directed to have, that this draft 119 was to model after the civil rights, and there is some of that language out there. But if we're really trying to use hate crime definitions for bias, and again, which will then tie into the other draft and reporting, we'd like to just be consistent with the 7 categories as defined by federal statute.
Further questions from the committee? Seeing none. Thank you, Ms. Chambers. Committee, I want to direct your attention to the staff comment as well on that second paragraph there. Concerning disability. So what has happened, you've just heard some different concepts come into play today from where the committee was before. So the committee was before in providing classes based on the Civil Rights Act and its progeny. So which would include the Americans with Disabilities Act. And so the question is presented to you in the staff comment associated with whether or not the committee would like to add the term disability. In addition to creed or religion, whatever we choose to do with that.
Madam Chairman,
Co-Chairman Olson.
I believe that's contained in the Attorney General's proposal. Disability is in the 18 US. So as a
So-
separate conversation, but so everyone's clear that just the word disability appears in 18 USC 249's list.
So the list in 18 USC 249 is, and actual or perceived isn't necessarily part of the list. If you want to add that in, right, then that would be important that the committee needs to intentionally amend in, whether it's actual or perceived. Religion, national origin, gender, sexual orientation, gender identity, or disability. Those are the words that we're talking about that the committee needs to consider for that amendment. Is there further public comment on the bill? With that, public comment is closed. Committee, back to you. Is there a motion on the bill?
Madam Chairman, because I really do think that both of these bills are related, that my preference would be to make motions after public comment for the hate crime reporting statistics as well. So we dispose of them at the same time.
Is there a motion on the bill?
Madam Chair, I will move the bill.
Is there a second? Seconded by Representative Provenza. Discussion on the bill?
Madam Chairman,
Representative Swanatzer.
I'd go ahead on page 2, line 1, amend the language to cite 18 US Code 249.
I'll second. Further discussion? Representative Washit.
I believe I heard on that motion that we were going to insert the numbers of the federal code rather than just use their definitions. Can I get a clarification on that?
Representative Swanatzer.
Yes, Madam Chairman, that'd be correct. When we write statutes, we generally just reference the federal code, and that way, if the federal code ever changes, the change automatically happens, and many states do that as well. So not every, we're not, federal law changes, which trumps state law, we automatically are in compliance.
Further discussion? Representative Washit.
Hey, Madam Chair. We've also had this discussion many times about the risk that federal law may change in a direction that we may not be comfortable with in the future. And that by listing this specific statute into our state statute, or specific federal code by number into our state statutes, then we are binding our state statute to future changes in federal law that would then require us to come back and either change the law if we didn't want to go the same way as the federal changes. So I would be opposed to this amendment. because I don't like the idea of tying ourselves to a federal code that might change in the future in a direction that we have no control over.
Senator Kolb.
Yeah, just clarification. So are we back to actual or perceived? Well, I'll just say I absolutely think that it's a perilous road we take when we talk about perceived. I think it becomes an arbitrary and capricious thought that is basically undefendable by someone trying to defend themselves. I mean, how can you have anything to say about it because someone perceives something? So it's merely a feeling. It's a conveyance of a feeling. And I think that is the peril I see here with this. We subject people to a law that's, frankly, I'll use a word, squishy. And how do you defend yourself from that? So I absolutely am not in favor of adopting this amendment. Thank you.
Representative Swanitzer, did your motion include actual or perceived, or just the definitions as found in?
It would just do the definitions as found, but a crime, Madam Chairman, would have to be committed. It's not a perception ahead of a crime. It's once a crime has been committed against a person or property. But I guess that's a separate, but my motion is just to add 18 U.S.C. 249 in line with what the Attorney General's office has requested.
So the concept of actual perceived is not part of your motion, correct?
No, Madam Chairman,
Okay, that answers your question.
that's in conceptual.
Okay, further discussion on the motion? Representative Oakley.
Madam Chair, quickly, I think I'm going to be against it as for the same reasons that Representative Washit said. I think we can find a way, but I just assume we make our own, state law definitions. I feel like we haven't even looked at them. I don't know if everybody's found 18 USC here or knows exactly what, and anyway, for that reason, I just as soon have a standalone state law discussion. That's my thought on it.
Okay. Representative Yan.
Maybe to give a little of a different perspective. So if it's a federal offense, so it is a hate crime statute, it's a federal law, and someone violates the federal law, yes, the federal government could assert jurisdiction if for some reason it's not a violation in state law, so the state wouldn't have jurisdiction. But the state, if the state law matches the federal law, no matter what, it's still going to be a crime under federal law, whether the federal law changes or not. It just makes sense for the state to be the one handling that trial and convicting or not convicting a criminal, rather than having this go to federal court when we could just as easily handle it as a state of Wyoming. So I would be in favor of just matching the definition, plus with the secondary effect that it does make the hate crime reporting statistic easier, because there's no ambiguity between what is in the our state statute and what's in federal statute. Thank you, Madam Chair.
Further discussion, Senator Cost.
Thank you, Madam Chair. I just need some clarification, because I thought all this was doing was replacing race, color, sex, creed, religion, or national origin with religion, national origin, gender, sexual orientation, gender identity, or disability of any person. I didn't think there was anything else to that. Am I missing something?
I don't think so, Senator Cost. No. All those in favor say aye. All those opposed? All those in favor, raise your hands. Yeah. All those in favor, please raise your hands. All those opposed, please raise your hands. That motion has failed.
Madam Chair,
Representative Swanitzer.
let me try number 2. My motion would be to add the word disability into on page 2 after the word religion.
I think Senator Cost has a motion, maybe potentially based on what his proposal was. I think the concern I heard from the committee members was they don't want federal law to change in a way that they don't feel comfortable with. So as Senator Cost thought the motion was just a replacement of the words that you see listed with the words that are in 18 USC 249. Would that be your motion, Representative Wanitzer, which includes disability? No, you referenced the statute citation. You referenced the federal statute.
And that was my first motion that failed. So my second motion would be whatever you just said, Madam Chairman, that would include the word disability from 18 US Code 249. I think I'm missing something. I would like to add the word disability, however, the committee best sees it fit to add into our state statutes.
So the motion is to add the term, the word disability on page 2, line 1. Is there a second? Seconded by Representative Crago. Further discussion? Representative Larson? We're adding the word disability on page 2, line 1. Sure. Representative Yen?
Madam Chair, so this still suffers from the problem presented by the Attorney General's office and those that gave public comment, which is that there would still be a disambiguity between our definitions and federal definitions. So I'd prefer to just copy over instead of reference the definitions from USC 249 instead of this motion. Thank you, Madam Chair.
Further discussion on Representative Wanitzer's motion to add the word disability? Senator Cost has called question to me quietly. Question having been called, all those in favor, please say aye. Aye. All those opposed? That motion has passed. All right. Further discussion on the bill. Representative Wanitzer.
Thank you, Madam Chairman. And as I think the committee knows, I have an amendment before you, which adds on page 2 after line 2, subsections C, 1, 2, 3, and 4. And so in full disclosure to the committee, what I'm attempting to do with this amendment is provide what would be considered a bias motivated crime to a person or property in lines with the exact same penalties currently in law. But you as a prosecutor could charge under what we'd consider bias motivated crime statute or under and 6.3, a crime against property, a crime against a person. And so we would have a place in our law, what would be considered a bias motivated crime statute or a hate crime statute with no additional penalties above what would already be allowed. It would really be a prosecutorial tool for what I would consider a very rare but egregious offense where a district attorney or county attorney would in fact want to say this is a crime that would be perceived as a bias motivated or hate crime. Therefore, at least the discussion I've had for the past decade has been Wyoming is one of 2 states now with a hate crime law or bias motivated crime law. We may likely be the last state. This would say we do have such a statute on our books for crimes against people or property. It wouldn't be allowed that a prosecutor could charge under this statute or another statute. No enhanced penalties. Nothing really necessarily changes in our laws besides having a qualified bias motivated crime statute that would be able to be used if a prosecutor chose. And that would be my motion. It's the language you see there on handout, I think, just passed out.
Thank you, Representative Wanitzer. Does everyone have the proposed amendment? All right, it has been moved by Representative Wanitzer. Is there a second? Seconded by Senator Cooper. Co-Chairman Olson has an inquiry.
Yeah, trying to word that the right way. Representative Wanitzer's previous amendment to the bill added the word disability, which is covered in subsection A, but your subsection C doesn't contain it. I'm assuming you want to clean that up.
Madam Chair, that'd be correct if I would, that is part of the motion as well.
Further discussion on the motion and the proposed amendment? I sense there's a chilling effect in the room. This bothers me greatly. Representative Yen.
Madam Chair, so, I think I like this amendment, and I've had concerns from others that think that this could allow for additional punishment. And as far as I know, I don't think it does, but I think I would like to hear from a lawyer to explain why it would not be additional punishment for it to be a hate crime bill.
Representative Oakley. Representative Oakley, we'll have a county attorney tell us.
Madam Chair, the basic answer would be no, it would not have enhanced penalties because it specifically calls for it to be in line with what our statutes currently are. So a misdemeanor, it's a 6-month misdemeanor, which is the same. The longer, more confusing answer, I suppose, is that prosecutors can charge 2 or 3 different crimes for one event. So that happens quite frequently. But generally, no, this is a different, it adds elements for a prosecutor to prove. So that adds due process for the defendant, holds the government to its burden that it has to be proven. That's what it was, similar to what Senator Kolb said. Then it's not a perception. It is an element that the government has to prove happened beyond a reasonable doubt. And then, of course, you can see the associated penalties are the same as far as being a 6-month misdemeanor, if it's a misdemeanor, or if it were over $1,000, which matches our statutes now, then it could be charged as a felony. But even then, the felony still holds the same penalty as other felonies similar currently in statute.
Thank you, Representative Oakley. Representative Washit.
Thank you, Madam Chair. Maybe Representative Oakley is the best one to answer this question, but the language about intimidate or harass, trying to recall, but I don't remember that Wyoming has a specific harassment crime presently. So this would be a new crime of intimidate or harass. My memory is that the only harassment language we have in statute is under the stalking statute. And so I just don't know whether what does it mean to intimidate or harass? And is that defined someplace else in the statute? And is this a new type of crime that involves intimidating or harassing that doesn't exist anywhere else?
Representative Swanitzer, do you know?
I'm looking it up, Madam Chairman, but I know we have a law against intimidation, and harassment of state officials, not even in stalking. So no,
Well, let's go find that. Let's take a minute. I think, Mr. Fuller, do you have some comments?
Yeah, Madam Chairman, Representative Washit, intimidates used in a couple of different statutory sections. I don't believe it's defined in the general definitions of the criminal code. I think it's used in obscenity. It's used, and I think in arson statute, there's a couple others that escape me right now. Harass is defined though in I think the general definition section of the criminal code. So that term is has a definition that would apply to this this amendment.
Representative Washit.
Just a follow-up. So harass is defined, but is harassing by itself a criminal act in our statutes for other than public officials?
Representative Swanitzer did point out game animals cannot be harassed, and politicians. It's good. Mr. Fuller?
Yeah, Madam Chairman, Representative Washit, stalking, I think is the closest.
Representative Oakley.
Thank you, Madam Chair. So harass is defined in the stalking statutes, and I think it would be specific to, I mean, it's a course of conduct about stalking a person. If if a term isn't defined in the law, then it's what the word generally means, and that's how it's even given to a jury. So a prosecutor would look at the action, whatever the alleged crime is, and would say, that was done because with a purpose to intimidate or harass. And then it also then has to have that element of, in this case, either with and in the intent to intimidate or harass, they did the property destruction, or with the and because it was based on that class. So all of those things would have to be proven beyond a reasonable doubt. So intimidate or harass means what their generally understood definitions are. And that's, again, unless we chose to define it, that's then how a jury decides. Did they do that with the intent to intimidate or harass? And it means just exactly what you think it means, basically.
Representative Washit.
Thank you, Madam Chair. So to intimidate or harass someone because of their race, color, sex, disability, religion, or national origin becomes a crime. But to intimidate or harass a person for any other reason would not be a crime unless it was repetitive under the stalking code. Is that what I'm following?
Madam Chairman, there's also harassment provisions in electronic communications, interceptions of oral or electronic. It's in 73702. And so if you do harassing phone calls, text messages, it's also a misdemeanor as well. So it does appear throughout it. I wouldn't say ubiquitously throughout our statutes. It's statutes all in the last 20 years, but harassment can be a crime.
Mr. Fuller. Let's go to our paid lawyer.
Madam Chairman, the question, I think Representative Oakley summarized, if the terms aren't defined in this section, they're going to be interpreted according to their plain and ordinary meaning. I think beyond that, the only other thing I would note is that this language regarding intimidate or harass is just one element of the offense, and it goes to the intent, the person's intent versus the actual action, which would be those items that are listed in paragraphs 1 through 4.
Representative Oakley.
Madam Chair, and in addition or in agreement with what Mr. Fuller just said, and in response to Representative Washit, so he said it wouldn't be a crime if you intimidated or harassed somebody that wasn't a part of these classes, but that leaves out the next part of the statute, which is then you do property destruction or a battery on them. So if you did something that is property destruction or battery on somebody, that is included in Wyoming statute already, and the penalties would be the same. So it doesn't have enhanced penalties, I would say, for different classes, which I think is important about this. As far as what a lot of people concerns we've heard about, and I've always struggled with, this whole discussion about hate crimes, because I could never wrap my head around why you would ever have enhanced penalties, for how you look or a factor about you, right? So it shouldn't be that if you batter a white man, you get one penalty, and if you batter a black man, for example, you get another one. One thing that this does not have increased penalties, but it allows a prosecutor to charge it so that if that designation is appropriate, that somebody did it because of that motivation, that can be attached to their, whether it's criminal record, heaven forbid, but, their criminal record, or it could be that designation, but it will not be that class of person would have a higher penalty associated with doing the property destruction or battery against them.
Co-Chairman Olson.
Thank you, Madam Chairman. I have a question then I'm assuming it's going to be Representative Oakley. So how does that work with the sentencing if you were to charge both the underlying offense, the battery, and the battery because of the list that we have, and you actually end up with two, let's say you end up with a conviction on both, are those sentences automatically concurrent, or is that just going to be up to the judge at sentencing? How does that work?
Representative Oakley.
Madam Chair, Co-Chair, and I would actually like possibly if Mr. Fuller has thought about this, I think the way this is, it would be a lesser included. So that actually it could only be once. If there's any different element and it were two crimes completely that was not a lesser included, then yes, technically somebody could be sentenced for two different crimes if there's different elements. The way this is, I believe it would be a lesser included, so they actually, and that goes back to Representative Yin's first question, I don't think then they would be subject to double penalties, because I believe that this would be a lesser included.
Mr. Fuller, on the concept of a lesser included offense and a quick explanation to the non-lawyers of the committee.
Yeah, Madam Chairman, I'm not sure exactly how this would pan out in terms of that, but the concept would be for purposes of sentencing, it's possible that given the similarity of these offenses, the sentences would merge into a single sentence.
That's why we have Mr. Fuller. Representative Crago.
Thank you, Madam Chairman. I actually do not think you could, you could charge them both, but I think I'm fairly confident it's a lesser included too, because the language is exactly the same. And unless there's an additional element, which there is on this new amended version of the bill,
It's the Blockberger test.
yes. And it's gonna roll into that. I don't think it creates a separate crime, and I don't think you could be convicted of both, only one or the other. The way I read this, we have an extra element, the prosecutor would have an extra element above whether we're talking battery or property destruction, they would have to prove, and most likely be in a very egregious case the way otherwise they're gonna take the safe bet.
Right.
Prosecutor's gonna take the safe bet, get the conviction and get the sentence, unless it's really egregious, so.
Representative Provenza.
Thank you, Madam Chair, and forgive me if maybe I missed this or I'm ignorant, but since it sounds like we can't get a conviction of both because they're similar, would a prosecutor then be more inclined to go for harassment that's not attached to this or these other crimes because it's easier to prove? Because in the above subsection, you have to consider why that person committed that crime, and trying to prove what someone's state of mind was is incredibly difficult. So is it going to not be used because of that? Is that a concern? Thank you.
Representative Provenza, I think that that's a fair assessment, but trying to predict the discretion of the prosecutors is something I have really struggled with for a long time. Recognizing that they are elected officials, their offices are elected, I think that provides some indication for those types of crimes that would warrant these types of prosecutions that is to occur. But I do think there is an additional element, and there's no way I think to avoid that if you're seeking something such as this. So if you want to have a statement in the law that says there are protections or there's going to be a crime associated with criminal activity motivated by these purposes, then you have to prove that. This is the only way to do that. The only alternative is not to have it as an element for a prosecutor to prove to a jury, and it's a sentencing enhancement. Those are the only two options that can go into the criminal code that addresses the issues. Either a sentencing enhancement or an additional element for the court to prove, for the prosecutor to prove. This is what's before you right now. Representative Oakley?
Madam Chair, thank you. I'd just like to add a little more. I completely agree with what you said. You said that prosecutors, in Wyoming, the county attorneys, DAs are elected positions. So I was using this as a really simple example. Let's say somebody had a racial slur spray painted on the front of their house. Then that would fit this perfectly, and that person could have that designation of having committed that type of a crime. It creates that category. If the same crime happens, except let's say they didn't do a racial slur, they just spray painted stuff. And the victim of that crime said, I think they did it because of my race. And say, well, okay, I hear you, but I don't have any proof of that. So they could still be, of course, as you know, any citizen having been a victim of property destruction. But I mean, I would say that of course a prosecutor in their community, when it's appropriate, when it's correct, and I think this is important, when it's provable, then this is a tool.
Further discussion? Representative Provenza?
And just a real quick follow-up. So since there's no language that says it can't be used in conjunction, would that be a decision by a judge that says you can't charge both of these crimes, or we can't go for penalties? Because Senator Nethercott, or sorry, Madam Chairwoman, you mentioned enhancing that sentencing based on that behavior. So I just want to see in black and white where we're not enhancing penalties, or there's not that option available if one were to really want to go after it.
Representative Provenza, I think you can look in the proposed amendment where it provides the possible sentences associated with the conviction for the crime. And it would be up to the judge to sentence within that statutory construct as found in the amendment. I think we're going to get confused here. Representative Washit?
Thank you, Madam Chair. I guess I'm struggling now with the whole premise that was brought to us, and we heard a couple of hours of testimony about people being fearful and about the legacy of a murder that took place many years ago, and how Wyoming need to rectify that by passing a hate crimes bill. And other than being able to say, yes, now we have a hate crimes bill that makes a hate crime a misdemeanor in Wyoming, I don't know where this satisfies any of those initial premises, that people were fearful, they couldn't walk down the street holding hands, they were all these things. And I don't know that we gain the solution to the complaint about Wyoming not having a hate crimes law. And so to pass this law just so we can say, yep, we got one, check the box. I still think we're going to be subject to all of the same criticisms that we're subject to now if we pass this. And so it just seems to me to be symbolism over substance.
There is a felony in the amendment. Want to make sure that's clarified for the committee. There's both a misdemeanor and a felony associated with the misdemeanor offenses and the felony offenses. So that allegation that it's just a misdemeanor is incorrect. Just want to make sure that's corrected. I do think it's a significant piece of an amendment, and it's far different than what we've done. And if it doesn't satisfy some of those concerns, I'm not sure what would. And so that's actually where I stand on it. It's probably the most we could do. And I think it's a pretty profound amendment, quite frankly. So Representative Oakley?
Madam Chair, just quickly, since the example of murder was used, yet again, that's always something that's been interesting to me. I mean, first-degree murder is mandatory life in Wyoming. And in Wyoming, mandatory life means you will die in prison. So there really isn't an enhancement there. And I think the conversation has changed more towards this level of legislation rather than, again, like these huge enhancements for the big crimes like murder. Because the reality is if you murder somebody in Wyoming, and it's proven, you're going away. So this is more what you're talking about when Walmart comes in, there's Walmart employees. I don't think the murder statutes are really what we're discussing. So I think this does hit what has been the heart of the discussion.
Further discussion? All right, seeing none, all of those in favor of Representative Wanetter's motion to adopt proposed amendment to 22 LSO 119 version .3, please say aye. Aye. All those opposed? That motion has passed. You're calling division? All those in favor, please raise your hands. All those opposed? That motion has passed. Representative Yen?
Madam Chairman, so now that we're back on the motion, I would like to make sure that we synchronize our list with the federal definitions list. So I would ask that we insert both gender and gender identity into this list. My concern as well is that the group that came to us in August, I think, without having these two in the list, it becomes pretty problematic. So that's my motion. Let's see where the committee is at. Thank you, Madam Chair.
A couple of things I will say, and I know it's in the afternoon and we're kind of at that point in the afternoon of getting tired. I have heard from members of the audience that it's hard to hear us.
So Madam Chair, my motion is to copy the definitions from 18 US Code Section 249, I believe, and put that in the list of our current bill under C, I believe.
Is
Thank
there
you,
a
Madam Chair.
second? Does everyone understand that motion? You have to communicate with me. Representative Larson does not. I'm getting a furrowed brow. Okay, is there a second to the motion? Seconded by Provenza. Discussion. Representative Yen.
Madam Chair, just to give clarity to the committee, to make sure everyone knows, the list in 18 US Code 249 is religion, national origin, gender, sexual orientation, gender identity, or disability. And that would replace on the amendment, race, color, sex, religion, or national origin. Thank you, Madam Chair.
Further discussion. All those in favor, please say aye. All those opposed? No. That motion has failed. Question on 22 LSO Bill Draft 119. So this would be the decision for whether or not to sponsor this bill as a sponsored joint judiciary committee bill to the 2022 legislative session. This will be a roll call vote.
Senator Cooper,
Senator Cooper, you got to vote.
Senator French, Senator Kolb, Senator Cost,
Aye.
Representative Crago, Representative Larson, Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Washut,
No.
Representative Rodriguez Williams. No. Representative Ian,
Aye.
Representative Zwanitzer. Co-Chairman Olson. And Chairman Nethercott.
Aye.
Madam Chairman, by my count and by the interim rules of this committee, that bill fails by a vote of the House members.
All right, with that, we will move on to the bias crimes reporting bill. Mr. Fuller, can you walk us through that bill? This will be 22 LSO 120 working draft version 4.
Yep. And Madam Chairman, I'm happy to repeat my discussion my overview if you wish. So this bill requires the Division of Criminal Investigation to collect and report statistics concerning crimes that exhibit evidence of prejudice based on specified categories. This is based on Utah law. that was referenced during the June meeting. So starting on page 2, lines 10 to 13, this amends 71102, which requires all law enforcement agency, courts, district attorneys, correctional institutions, probation and parole to maintain a public record of crime and criminals in the operation of the criminal justice system. The statute as it exists requires the Attorney General to provide uniform forms for reporting all information necessary. On lines 10 through 13, this would add a sentence that requires that these uniform forms must ensure that data and information concerning crimes that exhibit evidence of prejudice based on specified categories can be reported. Then moving on to page 3, current law requires the DCI to at least annually compile a report on Wyoming crime statistics. And the language on lines 15 to 17 would require the report to include statistics concerning crimes that exhibit evidence of prejudice based on the categories which are listed on lines 19 through 22. And then those lines 19 through 22 would require the division to establish a statewide uniform crime reporting system to develop statistics concerning crimes that exhibit evidence of prejudice based on race, color, sex, religion, national origin, ancestry, and ethnicity. Madam Chairman, the members of the committee, those categories are taken straight from Utah's law. And with that, I'd be happy to stand for questions.
Thank you, Mr. Fuller. Ms. Chambers, it was my understanding that we were going to hear from DCI concerning NIBRS reporting. Are we going to do that? All right, let's hear about NIBRS reporting, how the state is implementing that system.
Madam Chair, Kara Chambers, Attorney General's Office. I'm accompanied by, I'll let her introduce herself.
Madam Chair, Allison Moore, I'm the Deputy Director of DCI over our Criminal Justice Information Systems Division.
Welcome.
Madam Chair, if I may, at the last meeting, there was several questions about how DCI currently collects incident-based reporting through NIBRS, which is the National Incident-Based Reporting System, and some concerns about compliance from local law enforcement. And so, I mean, we can present this however you would like, but what we thought we would do is sort of have Deputy Director Moore sort of outline what her division does, very generally what NIBRS is, who reports into it. And she has compiled a list because I believe the concern was agencies that are not compliant with reporting into NIBRS. And so we can talk a little bit about that. And then if there's other questions about what will be collected and how NIBRS interfaces with your bill draft 120, we can absolutely address that at the time.
Yeah, so I think for purposes of time, what we would like to hear is how NIBRS interfaces with the bill draft. So does the NIBRS system request reporting associated with bias motivated crimes?
Madam Chair, yes, it does. Part of NIBRS, I think I want to put this out there too. NIBRS is incident-based reporting, so it's not, the information's coming from local law enforcement, not coming from the court. So it's not necessarily based on convictions or even charges. It's based on what law enforcement is seeing, and it does include bias motivation.
Madam Chair, if I may, the big question about NIBRS and the change from what we used to collect is there's a largely expanded category of crimes. The UCR summary report, which is what many people are familiar with, had 10 categories of crime. And so what they found is that there was like the 10 big crimes, and any underlying charges that were related were kind of ignored. So if you had a case where there was a homicide, a sexual assault, and a robbery, that would just get reported as one homicide. NIBRS intends to collect data on every single incident that was involved, so it would count all three. The other thing that NIBRS does is it does have the ability, and it's required to collect data on bias motivation. And it collects data on race, religion, disability, sexual orientation, ethnicity, gender, and gender identity. That will not change. Those categories will be in the report always, whether law enforcement reports into it or not. That's a training issue that we can talk about. I don't think it's necessarily impacted by this bill draft or the prior bill that is no longer. But we can talk about that if you would like to. This bill that you have presented is, I don't think DCI has that. We don't have any concerns with that. We already provide that uniform form for reporting. It is NIBRS and it does include bias. If the will of the committee is to include this language, I don't think we have any problem with it. I'm not going to go down the road of definitions because that's already in there. Those boxes are going to stay there. Those 7 categories are there.
And so, Ms. Chambers, I understand that the NIBR system is a somewhat new system. And so some timing of that, and do we have the data that's been inputted for us to be able to understand its meanings or understand some of those crime statistics?
Either one.
Madam Chairman. NIBRS, we began using NIBRS only on January 1, 2021. DCI actually started using NIBRS in part in 2016. And we knew then that summary data was going to go away. So that's why we began using NIBRS. There were some local law enforcement agencies that transitioned to NIBRS back in 2018. All agencies knew that as of January 1st of this year that we could no longer collect summary data because the system won't accept that information. And that system that I'm talking about is how we transfer that data to the FBI.
Madam Chair, if I may, the other bit of the NIBRS conversation was which local law enforcement agencies are or are not reporting into NIBRS and what the reasons are. Deputy Director Moore has compiled a sheet that we can provide to you. I've provided to Mr. Fuller about agency by agency of 50. There are 59 law enforcement agencies in the state of Wyoming. And as you heard from Director Williams yesterday, that there are 38 that are reporting into NIBRS and 21 who are not. And of those 21, the common reasons had to do with issues with their vendor. Really lack of resources and staffing issues, whether the vendor, the way they were extracting data from the record management system that wasn't interfacing properly with NIBRS. And so there was a lot of errors and a lot of back and forth between DCI staff and whomever at the local law enforcement was tagged to enter that data. And so it is not, I don't want to throw law enforcement under the bus saying they're just not reporting. Now, we do have some agencies that have quite frankly said, this is not a priority for us. We don't have the manpower. We don't have the time to do this. And that's an issue.
Can you share us who those agencies are?
I can. There is a list, I think the most. Park County Sheriff's Office is probably the most notable.
Park County?
Park County. Yes. On the other end, Pine Bluffs Police Department has indicated that they have staffing issues and they only have one person training. And I will let you know that when I went through the NIBRS training, the chief was sitting at the table across from me. And so we both went through NIBRS training. And those are issues that, we can sympathize with versus saying, I don't want to, or I don't have the time, or you can't make me. I don't know how you would like to interpret that. But again, I will say the majority of noncompliance has to do with vendor issues. And really when the rubber hits the road, that means money. They can't afford to upgrade with whatever the latest and greatest version that the vendor is offering because it's just too cost prohibitive. And so because as Ms. Moore indicated, compliance became mandatory with NIBRS beginning January, we tracked January, February, March, April, May, June, because there were some agencies that were reporting and then fell off because of vendor issues. There's some that have never been able to report because of vendor issues or unwillingness to report. And we have this broken down. And again, I have provided this to Mr. Fuller, but we weren't sure how you wanted to.
Do we have an electronic version of that, Mr. Fuller?
Yeah, Madam Chairman, just sent it.
Great. Yeah, here it is. Thank you. That's to all the Judiciary Committee so that it's here.
If I may, please, one thing that we would like, because I don't want to just come here and present a problem. Obviously, I'd like to present a solution. One thing that that struck me after I took the training, and actually Allison and I took it together with the chief, was that it was really apparent to me that we needed to do a better, different job at training this. Each agency's interface with NIBRS is really dependent on their vendor and their record management system. And I really do think, and so it looks different on their end than it, you know, so if I have Spillman versus who else is out there, web incident editor, you know, my local interface may look very different. And so it occurred to us that perhaps some specialized, maybe even not necessarily regional, because what you'd want to do is you'd want to train people who all had the same vendor together to really kind of triage their specific reporting issues. And then, you know, beyond that, whether it mean, and I really probably think it should I personally think it would have been helpful to have that smaller group one-on-one interaction with a little bit more back and forth dialogue specific to their vendor. And so that is a proposal that we'd like to make, but we realize that this, you know, at the end of the day, everything has a cost. I have reached out to the University of Wyoming WISAC, the Wyoming Survey and Analysis Center, because of course they are our state statistical analysis center, and that's a designation from the Department of Justice. And they are the ones who my agency, meaning the Attorney General's office, and many other state agencies rely on to look at this data. For example, your entire conversation yesterday about juvenile justice, WISAC has been involved in trying to get data and crunch the data. WISAC is very vested in trying to help Wyoming with our NIBRS reporting and making sure that we have consistent, accurate data. And that's something, you know, having that, being able to leverage that training and technical assistance that they could provide is something that we can look into. But again, you know, these are things that are costs, and we'd like to not shift this on to the local agencies because of course, part of the problem is they don't have the money to upgrade the vendor in the first place. So, you know, I don't want to make this all about money, but I do want to say that, you know, sometimes there are solutions that require some capital investment. But beyond that, I'm happy, believe Allison and I are happy to answer any specific questions about reporting. I don't know what we could necessarily provide other than the fact that when it comes to biased reporting, you know, we've talked in circles around this. I mean, these categories have been there for a while. It is a known thing. Law enforcement is trained on bias, maybe not to the degree that some would like, or maybe that if there's a recommendation of a type of training. I've spoken with the Wyoming Law Enforcement Academy and they said, you know, we do bias training, and I believe Byron Odakoven will appear virtually to maybe expound upon that. But if there's something more specific, we're happy to look into that.
Questions? Representative Washut.
Hey, Madam Chair, just a quick question. What happens to Wyoming when we don't have 21 agencies reporting 2021 crime data? Do we get eliminated completely so that we don't show up in any of the national statistics? Or do we under-report with just the 21 agencies and then get an asterisk next to our name? What happens when Wyoming is non-compliant?
Ms. Chambers.
Madam Chair, Representative Washut, our grants can take up to a 10% hit for non-compliance. So we're talking dollars. I don't have that specific amount in front of me because I'm not entirely sure what all grants could be affected. But certainly the grants that DCI receives, I hope not the grants that my division receives, which are Victims of Crime Act money and Violence Against Women Act money. But, you know, it would implicate probably a large amount of Department of Justice grants. And so that's, I mean, that is typically the carrot and the stick that the feds have over us and that the state has over other agencies. The issue with that same
That
thing
includes
is
human trafficking, right? Crimes against
Yeah,
children.
yeah.
So sticks in the mud doesn't help anybody, harms kids. That's the point, right?
Yep.
That's the point, Representative Washut. We're facilitating human trafficking by being difficult. Representative Washut, further comments?
I do. I just want to clarify that, you know, we talk about NIBRS being a new system. In fact, it was created when I was still a cop, 1991, 30 years ago. And so here we have Wyoming, 30 years later, non-compliant, causing the state of Wyoming to lose grant money. And, you know, if agencies say that that's simply not a priority for them, then, you know, maybe we need to look at some step to offset that grant dollar loss that the state's going to encounter because they're not participating. But my question was, what happens to our crime statistics? I understand about the grants, but I think there's a question as to, do we simply get no count at all on the national statistics? Do we get undercounted? Do all of our statistics then become questionable because instead of having 59 agencies reporting, now we only have 38?
Madam Chair, Representative. It's my understanding, so DCI puts out a crime in Wyoming report annually, and we include all of the statistics in there. In that report, we also indicate which agencies are not reporting. So it shows that there's that missing information. The FBI does something similar when they put out the crime in the US report. And so they'll indicate the percentage of data that they received from Wyoming.
Madam Chair, if I may add on that, if we don't have people selecting particular categories, it's that difference between 0 or not reported, because 0 has a value. Not reported means we didn't get the data. And those are distinctions that we have to make on those reports, because it's not 0, it's just not reported.
Ms. Chambers, it could be, I mean, because the state receives significant federal dollars and grants through the Department of Justice for crime investigations. And so for some of these counties and local law enforcement agencies, there's really no hook or stick to get them to cooperate with crime reporting. But we could, right, as a state, we could withdraw dollars allocated to counties that were uncooperative. The county commissioners are in the back of the room, so I'm doing this on purpose. My county commissioners primarily, but that would be an option, is to reduce or make it contingent upon the cooperation with these crime reportings, because the money is so significant that the state receives. But law enforcement really in the state couldn't operate without many of these federal grants that we receive from the Department of Justice. Is that fair to say?
Madam Chair, that is fair to say. And I would note that it would have to probably come down to state dollars, because a lot of these agencies don't receive pass-through funding through DCI. So we don't have that effect. And so you are absolutely correct.
Representative Rodriguez-Williams.
Thank you, Madam Chairman. Ma'am, according to the NIBRS website, every state has a different level of reporting. So we're considered one of the 20 states that are NIBRS data only. And there's something else called summary reporting system, in which there's 25 participating states. And then 5 states that are only summary reporting systems as well. And there's 5 of those, as I mentioned. Can you talk about the different levels of these reportings? And when we're talking about funds, being eligible for funds, et cetera, what that means?
Madam Chair, Representative Rodriguez, I'm going to start and then I'm going to turn to Allison. So the difference between NIBRS and summary is the old system. That was the UCR. And so that was the one that had the 10 categories, has been around for a very long time, and so would have more agencies that are compliant. I'm not sure about this distinction between data only or NIBRS system. Are you familiar with the distinction per se? But I will say that for an agency to become, agency meaning DCI, because we filter through. So for DCI to be NIBRS compliant on their website would mean that all of our reporting agencies have been, is the term certified or accepted? They have to pass certain tests for data integrity. And so I believe the distinction would be, we're probably in the category where we don't have full NIBRS compliance. We aren't 100% reporting into NIBRS because we don't have all of our law enforcement agencies being able to transmit data. And so I do believe that is a distinction between the categories. And then I apologize if there was a second part to that question of if that was tied to the funding specifically, like what category you were in, or if, I apologize.
Representative, yeah.
Yes, just if there was any distinction between funding available for those 20 states that are participating in NIBRS and the 25 that are participating in NIBRS and the old system.
Ms. Chambers.
Madam Chair, Representative Rodriguez-Williams, I would have to look into that. My guess is, my understanding is that summary was going away eventually. And my guess is that we're just having some dual overlap at this point. But the general statement that I've always received is that it's a 10% hit to your funding. And I don't know if Ms. Moore has additional information.
Madam Chair, Representative, we recently went through some of our federal grant applications, and those typically will ask if we are reporting through NIBRS.
Senator Kolb?
Thank you, Madam Co-Chair. So help me understand this. This is a mandatory thing, and yet we have non-compliance. So we have a statute that has no repercussions currently for non-reporting of a mandatory report.
Tis a theme for the Judiciary Committee.
I've heard this before.
You have heard this before. It's time to start taking some money.
So I came up with that idea also that we just penalize direct distribution on at least on a proportion of money we lose on the penalty that we're talking about at your level to the counties and make ourselves whole. Because it is absolutely ridiculous. I mean, I think we frankly, obviously there needs to be penalties. Penalty can't be, you didn't do it on, okay, we don't have data. Who's going to get complete? You can't do that with your own child. And not to say, these entities are children, but we need to get compliance. I mean, everything that I've heard, I'm a new person here, is all trying to be based on data. Yet then I hear we have rules. This is the second time I've heard about rules that are, mandatory, but yet no compliance.
Laws.
Laws. Better yet, we have a law with no consequences. Well, that's no law at all. You know how that joke goes about law enforcement and enforcement. So we need to get something. Either we can cook a penalty up. I'm game for anything to make a change here because we don't have a change yet. We don't have data yet, and the future doesn't look too bright that we're going to get any more data than we currently have. And I'm not going to defend my own county because apparently we're 100% in one direction, and it's not the direction I'd like. And I'll ask questions about why that is, but I don't know. I think we have to be fair about it, but we need to have compliance. Thank you.
Madam Chair, if I may,
Yes.
I realize there wasn't necessarily a question there, but agreed. But that is also why we wanted to create this list for you, because I would put the folks in a category who would love to be compliant are having vendor issues and can't resolve them in one category versus someone who said, I can't be bothered. But I agree. And it is a theme. It is hard. It's, I hate to, my mom always said, if you have to ask why, the answer is money. A lot of times it's not for ill will or lack of interest. A lot of times it's, we can't afford to be compliant. And I will, having sat here yesterday and had to admit a failure of our agency, among other bodies of some 20 years of a law that had never, it came down to probably funding. But I agree. But I would also like for you to
Ms.
hear from,
Chambers.
yes.
Funding is not an acceptable answer. There are 38
understand.
agencies in the state that are able to be compliant. Can you speak to how they've able to achieve that?
Madam Chair, I believe it's a matter of priority. You are correct. But I just hesitate to not acknowledge some fiscal realities, but I would agree. I will say that I would like for you to hear from Mr. Odokoven, to hear directly from law enforcement, because I certainly don't want to be the one who's sitting here throwing these agencies under the bus. We are all part of this. We are a very data-driven society, very data-driven bodies as the executive branch, legislative branch, et cetera. And we do need the data. It's very important. And so I would agree, but we do need to figure out how to get compliance, maybe add teeth is the term I've heard. And we can certainly explore those avenues.
Representative Provenza.
Thank you, Madam Chair. So I'm seeing that there are just a few companies that provide this interface with the vendor and NIBRS. And I'm wondering, are these companies also working in other states with law enforcement? Why are they not why can't they interface here? What is the problem that our law enforcement. I think my police chief ended up having to pay well over $1 million to get the coding right. And I'm trying to understand why why they're not also liable, because they're supposed to provide this service and they're clearly not.
If either of you know, yeah. And is Mr. Otakoven on Zoom? If we can bring him in too. And if you know the answer, go ahead.
Madam Chairman, Representative, this is a problem, my understanding, nationwide with several of these vendors. It's not something that's just happening within Wyoming. Our staff that work in our uniform crime reporting section, when they talk to their counterparts, these are struggles that many of the states are having and with the same vendors.
Representative Washit.
Thank you, Madam Chair. Just a point, when I looked at Texas, state of Texas, among their UCR NIBR certified vendors was the company that Director Williams mentioned yesterday. And they list 3 of their products as being NIBR's compliant software solutions. So apparently in some states, NIBR's is working just fine with that company's software, but not here.
Mr. Otakoven, welcome to the Joint Judiciary Committee. It's good to see your face. If you would introduce yourself to the committee, I think you've been listening to this conversation. If you have any insight as to why we have 23 bad actors.
Madam Chair, Byron Otakoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. Let me take a slightly longer trail to answer that question, because there's several points along the way that I think need clarification. We started down this, Acting Director Williams outlined that basic process at your last meeting. And it would have been nice to have picked right up with that, had a refresher on that a little bit as we entered this discussion today. So I'll butcher his presentation slightly, but let me touch on several points. So Uniform Crime Report used to be a papered system. Every month, it was a fascinating chart that I had 2 different record secretaries complete, check the appropriate boxes, fill out our form, and I would sign off on that form and mail it to the state. State would review it. We would have a conference call on any reconciliation to previous months' reports, et cetera, to get to that level of, quote, a certified monthly report. We came to Congress, decided that we wanted a NIBRS, which is incident-based reporting, rather than a uniform crime report of grouping crimes together. And they also wanted to convert from a paper system to a computer system. In the meantime, agencies had started to purchase computer systems to write reports, do computerized reporting, rather than do the pencil and paper reporting and double and triple and quadruple entry of data. I think the most notable discussion we've had is on the electronic citations and the number of people that touch the citation along the way from the initial officer to the final judicial review. And that very same thing happens in law enforcement reports. So there were a number of $1 million computer programs purchased, for an abstract term, along the way as we journeyed toward being able to have NIBRS, the incident-based reporting system. So suffice it to say that if you were to go purchase a new system today, you would have the right computer with the right chip, with the right program and the right interface to then do that NIBRS reporting to the state, which I think is where a couple of references to other states may be. So you take, for example, the city of Laramie was mentioned. City of Laramie has been on the NIBRS trail for well over a decade. They have been in compliance issues for over 2 years. They've invested $1 million in upgrades to their computer in an attempt to have a compliant NIBRS submission, because you have to have your data submitted for a 6-month period, if I remember correctly, error-free in order to be considered compliant with your data submission for the incident-based system. they've started and struggled, started and struggled and started and struggled with that a number of times, yet to complete a 6-month run at entry of data and thus to receive their certification at significant expense and investment. So if we were to say that it's merely a whim, I would take exception with that or desire to not be NIBRS compliant. Now let's take the small agency. So the small agency, like Pine Bluff, doesn't have a staff person to do that. So in this case, the chief of police actually attended the training so he could become the NIBRS officer to do the NIBRS reporting. Now it's unlike our old system. I'm unaware that you can actually just do a paper system and mail it. Although I understand that DCI will work with very small agencies and help them through that process if they want to be able to do that paper report of reporting those incident crimes. And DCI will help them get that entered. But NIBRS is designed to be a computer entry system process. So depending upon where you are in your records management, your computer system, and your software version, you may have a conflict between those three that you're struggling with and trying to make major investments in to become compliant. So fine, if you will, but I would suggest you may want to start with the vendors who are looking at a outdated product and looking at our Wyoming agencies and seeking additional funding to get those computers up to current standards to be able to submit that NIBRS data. Maybe the point worthy of mentioning. I, for one, would like to have the NIBRS data because it makes more sense to have that incident. What happened on this day in these areas and how many of these crimes do we have would be great data to have. And I would like to wave my magic wand and figure out how to update everybody's computer software, computer chip, if you will, and move to that platform in a meaningful way. But it is about money in terms of upgrade with those. It is about the software that the Spellman vendor, for example, has. And yet a couple of counties have been able to upgrade and you'll see that they are Spellman, use Spellman software, but they are able to become compliant. So there's a host of issues in there. And remember that this was to be in place this year, and agencies, everyone has been working toward it that I'm aware of, with the exception of maybe one. And I'm not sure it's a flippant comment that they weren't going to comply as to an actual compliance point, if I may. And I would like to verify that they are truly, in fact, going to say no to being NIBRS compliant when it's required to be NIBRS compliant. So, Madam Chair, with respect, I would offer that there's more to the issue before we start down the road of looking at fines, penalties, or withdrawals, that we take a deeper dive and specifically understand where we are with those agencies and what direction they're taking to become compliant and the struggles and the hurdles that they have in order to do that.
Mr. Odakoven, I have no doubt that the answer will be that they need more money and to blame someone else. Technology, because well, we've heard that, I've heard that for 5 years on the Judiciary Committee for all kinds of reasons. So it'd be refreshing to hear a new novel answer as to why there is non-compliance with the law. That would be a refreshing concept indeed. I do look forward to hearing a follow-up at the next committee meeting on this topic and to hear from the Park County Sheriff as to whether or not that was a rejection of the NIBRS system or if it's a funding issue as well. And of course, hopefully we can get to the bottom of that. And then a greater understanding from these other non-compliant counties and cities as to what's going on. Some of it does appear to clearly be, technical vendor issues, with Spillman being the primary common denominator there. But, I do think it's important that everyone understands that there's a lot of watchful eyes on this issue. And follow-up will occur by the legislature, unlike in the past, hopefully. Further comments or questions to Mr. Odakoven or Ms. Chambers, DCI, Senator Kolb?
Thank you, Madam Co-Chair. Mr. Odakoven, is my understanding that all the law enforcement agencies in the state of Wyoming you represent, or is that not true? I mean, how many do you represent out of all the agencies in the state?
Mr. Odekoven?
Thank you, Mr. Chairman. Basically, all the sheriff's offices and police departments were in contact and worked back and forth. They asked me to appear on their behalf.
Well, and a follow-up, then could you possibly poll your members and get something going with what they think and what their solution is to this issue? I mean, is that possible? I'm just kind of asking an open-ended question.
Ms. Chambers wants to answer this as well. I'll go to her and then we'll go back to you, Mr. Odekoven.
Madam Chair, Senator Kolb, I just wanted to point out that the handout that we sent you was polling all 59 agencies and their direct responses, but I understand what you're asking, but I did want to point to that. And the other, if I may, I wanted to point out that the vendor that's entitled Web Incident Editor, that is a free system that's provided by DCI to the smaller agencies. And so you'll see a mixed bag of that. Most of them have been successful. They are the smaller agencies, but I just wanted to point out that that vendor is provided by DCI.
Ms. Chambers, I would ask for the next meeting as well that there's an update to what was just been provided to us, as well as a listing out of the compliant agencies, because I think that will be probably is that listed as well?
Madam Chair, yes, the compliant agencies have an X, the non-reporting have a small NR. This is all 59 agencies. We made sure to have that ready for today.
So the Riverton Police Department is compliant, is that correct?
Which page?
Just for example, I'm just.
Yes, they are fully compliant and have been for the past 6 months.
And the Goshen County Sheriff is as well.
Yes, and they use the system provided by DCI.
And the Crook County Sheriff is compliant as well.
Yes.
Those are very smaller agencies, seem to pull it off without funding
It's true.
concerns.
This is true. And
Wonderful.
it seems to be a mixed bag between Spillman and Web Incident Editor.
Right. Representative Oakley?
Madam Chair, thank you. And I suppose I would direct this at Mr. Odekoven, but Director Williams mentioned yesterday Spillman, which I know is, and I can see, has been having some issues. If you could speak to that. I know that's something that's used heavily in Fremont County, for example. And despite, I would say, maybe some commentary, but I mean, funding and technology are significant issues for many city and county law enforcement agencies, wouldn't you say?
Ms. Chambers? Oh, Mr. Odekoven?
Thank you, Madam Chair. Yes, the upgrades, Spellman, from memory, because that was the system that we used that I'm familiar with, had annual maintenance. Many times they would come with every other year upgrades, which had choices, if you will, on that. So we would have to, as part of this discussion with the 20 agencies that aren't, we need to understand where they are in their current upgrades, where they are in their current modules, whether or not NIBRS is compliant with their current county city computer, for example. With the module that is recommended. So we need to understand where that is in the greater scheme. Yes.
Further questions? Representative Washit.
Thank you, Madam Chair. Just so I'm clear, it was 2015 when the FBI announced that January 1, 2021 was the drop dead date for the summary reporting system. And after that, it would be NIBRS only, right? So they've been at least 5 or 6 years for agencies to come into compliance. Am I accurate with that?
Ms. Chambers or Mr. Odekoven, either one if you know.
In terms of the exact date, Madam Chair, I would have to verify that it is 2015. Bear in mind that in part of that NIBRS discussion for the Congress did the requirement. It was some time, a couple of years, if I remember correctly, before the federal government even put out what was expected and how this was going to be computerized and done. for the vendors to be able to react to that and start writing programs to be able to capture that. And if I understand correctly, we couldn't even submit for trial till 2 years ago, whether or not we could submit that data and whether or not it would be compliant.
Follow up?
Thank you, Madam Chair. Is it also true that it wasn't just a mandate from Congress that created NIBR, but rather a request from the International Association of Chiefs of Police and the National Sheriff's Association and other law enforcement partners with the FBI that sought NIBRs? I want to make sure we're clear. Mr. Odukova makes it sound like this is a Congress imposed mandate, but actually the law enforcement partners had a big role in this. True?
Mr. Ordakova, I see you nodding your head.
Madam Chair,
I'm hoping that your client's calling you.
sorry, I've been getting a lot of crazy phone calls this afternoon, but that is correct. The initial request of Congress came from law enforcement because of the subjective nature, and we've already talked about that umbrella of the Uniform Crime Report did not paint the total picture of crime in any one area because it, as we already talked, it took the most serious crime, labeled it, and did not capture that underlying crime for a clear package of what crime was in any one area. So in essence, for a number of years, we basically turned in two reports. The report that had the UCR, because that's how you could compare across state lines or across jurisdictions, and then we would compile our own incident-based report. So no, law enforcement's desire is to have that incident-based NIBR-style report. And again, as I said, if I could wave the magic wand and fix everybody's computer to make it happen, that would be fabulous.
Any further comments? All right, seeing none. I think you both are off the hot seat for now. Thank you so much. Thanks for providing that summary. I think it was very helpful to the committee. Again, we look forward to an update at our next meeting. And Ms. Chambers, if we can get that in advance, we'll make that part of our agenda as well, so that list can be published. Further comments on this bill?
Good afternoon, Madam Chairman, members of the committee. Chris Brown, representing the Wyoming Lodging and Restaurant Association. We've also been working with the coalition of numerous large employers and businesses and groups across the state on this issue as well. So I'm also here in that capacity. I want to start by just saying thank you very much for working this issue. I realize it has been arduous and is a tricky one heading into a budget session, so we appreciate the work you've put in thus far. We do stand in support of this bill moving forward. Madam Chair, in 2020 nationally, there was a 6% increase in reported hate crime incidents from the previous year. There were 18 reported bias motivated crimes in Wyoming in 2020. The 18 incidents included 11 incidents based on race, ethnicity, or ancestry, 2 based on religion, 2 based on sexual orientation, 2 based on gender, and 1 based on gender identity. 8 law enforcement agencies reported these 18 incidents, and they are police departments in Cheyenne, Cody, Evanston, Gillette, Laramie, and Sheridan. As well, they were reported by the Park County Sheriff's Office and the Sheridan County Sheriff's Office. Madam Chair, data can drive policy, and we feel that a more complete picture of the problem would help to resolve the issues driving the increase in bias-motivated crimes. Accurate and consistent reporting sends a message that bias-motivated crimes are taken seriously, and improved reporting may help increase the likelihood that members of vulnerable communities come forward to report when they've been the target of a bias-motivated crime. And so, Madam Chairman, we hope that this bill will move forward to the next session, and I'm happy to stand and take some questions.
Mr. Brown, thank you so much for being here. Any questions for Mr. Brown? Thank you.
Thank you.
Representative Connolly.
Thank you, Madam Chairman, members of the committee. Just a couple of quick words, and especially for the senators. that this was a bill, an idea that was brought forth in the last session, but debated on the House side. And one of the questions that came up on the House side was, how can we come up with a bill, a punishment, to address bias motivated crimes when we don't have the data, that we don't trust the data? We don't know if the data that we have is good enough. We're hearing all sorts of different reports from different jurisdictions across the state about how and if and when they report. So it was with the idea that the good chairs of this committee, in my mind, brought forth the idea that the interim committee topic and the direction that this issue should go for this budget session is on reporting. Let's get to reporting. Let's understand. And honestly, that's when we found out that there was a NIBARS issue, right? And jurisdictions were reporting differently. So we got to this point right here, and actually Senator Kolb, I had to chuckle kind of listening to your questions, which was, hang on, this sounds like this is already a requirement that jurisdictions, and it can be county sheriffs, it can be city police, it can be university, right? They're required to upload this information to DCI that then uploads it to the feds, and that's how we get our data, right? They should be doing it anyway, right? And we should punish them. But I think the House side actually thought about that and said, okay, we want them to do it, right? We want them to do what they are supposed to be doing. But it seems unclear because it's not in the statute. So let's have a reporting statute, a bias motivated crime reporting statute, and let's do it well. That will say to jurisdictions, to reporting agencies, you really need to do this, and we're going to put it in the statutes. So that's what you see before you, is that bill without a punishment, without saying to the county commissioners, for example, we're going to take away some of your funding. So what you see here is that reporting bill. But I'd like to put forward to you that this bill isn't complete. Because if we're going to go to what is the problem that we are attempting to solve, which this then gets to Representative Washit, well, hang on. The testimony that we heard last year was about, in particular, kind of anti-gay bias motivated crimes, right? That's what we were hearing about, and we're not seeing anything in these bills that really address it. So I'd like to suggest to you that if this bill moves forward, it really needs the amendment on the bottom of page 3 that includes the 3 categories that we don't have right now that NIBARS collects. Or else what you have is the federal document that they're supposed to be filling out. Then we have a new state statute that doesn't include all of the categories that are in the NIBARS document. We need to be consistent. So that amendment would include on page 3, line 22 or wherever else you want to put it, sexual orientation, gender identity, and disability. Those are the 3 categories that NIBARS collects data on, that we want our law enforcement agencies to be reporting so that, bless you, so that we know, right? So that we know, and then if we want to act down the road, we have the correct data. So thank you, Madam Chair, members of the committee.
Thank you, Representative. Questions for the representative? All right, seeing none, thank you. Further public comment on this bill? Ms. King.
Thank you, Madam Co-Chair and members of the committee. Again, Sabrina King with the ACLU of Wyoming. I will again be incredibly brief and say that we support both this bill, but I think more broadly the conversation about use of the NIBARS system and compliance. That goes, of course, beyond our ability to have proper hate crimes reporting. If we do that, we will automatically get that, but we will also have better information on crimes in general in the state. So I think really important conversation, really happy to see that happening. So appreciate that. But definitely also want to see a specific requirement that our law enforcement agencies are looking more deeply at hate crime statistics so that we can actually address that in the state. So appreciate the conversation, support the bill, but also support including sexual orientation, gender identity, and disability, so we can make sure that we are actually collecting all of the data we need to have to put the proper policies in place.
Thank you, Ms. King. Questions for Ms. King? Right, seeing none, thank you. Thank you. Further public comment? Is there anyone else online? No? Okay. All right, with that, public comment is closed. Committee, back to you. Is there a motion on the bill? Moved by, or Representative Yen?
Thank you, Madam Chair. I'll move the bill and have some discussion on it.
Moved by Representative Yen, seconded by Co-Chairman Olson. Discussion on 22 LSO 120 Working Draft Version 4. Representative Yen?
Madam Chair, thank you. I think we heard a lot from the good Attorney General's office that there needs to be some work done to make sure that we have accurate statistics across the board, regardless of whether it's hate crime or anything. Our crime statistics are bad, and it may affect us monetarily as well. So, I think it makes sense to move this forward, but I'd like to figure out how we can do that effectively to make sure that we have compliance across the board. So I look forward to hearing from the rest of the committee. Thank you, Madam Chair.
Representative Washit?
Thank you, Madam Chair. My feeling is that this bill doesn't get at one of the root problems that we've been talking about all summer, which is law that says you got to do something and then it's just not done. And so these agencies that are non-compliant with NIBRS, NIBRS would be our solution. It would give us everything that we're looking for here and more on all these other topics we've been talking about this summer. And I guess I'm hesitant to pass a statute once again to demand that agencies collect certain types of data that they should be collecting already and should be reporting to DCI already, unless we build in there some consequence for non-compliance. And I just don't know that this bill gets us where we need to go.
Further discussion? Representative Provenza?
Thank you, Madam Chair. We heard kind of similar points made yesterday and today that we don't have reporting on this. We're going to lose money for this because we don't have that reporting. And, quite frankly, I'm very disappointed to learn that this has been in the pipeline for so long and it's not being met. And so my concern is, who are we continuing to disservice? What problems do we not know about and can we not solve because we don't have adequate data? And what are we going to do with an agency that has consequences for the state budgetarily, but also doesn't have any real oversight that can make determinations about their reporting? Clearly, we need data, and we have a mechanism to do so, but we choose not to use it. So I think it probably shouldn't be a choice.
Thank you, Representative. Senator Kolb?
Thank you, Madam Co-Chair. I see this as kind of another paper tiger. It's saying something we like to do, but we don't really know if we have to do it because we have no data. We have rules, we're asking for people to do something, but no consequences for them not doing it, which pretty well is going to equate to what I've heard in the past, meetings we've had about no compliance. So I don't see where this gets anywhere. I think we have to focus our efforts on compliance, because that seems to be the first step of moving forward with anything. Because we've heard, different views about something good or bad or needed or not needed. We don't factually know anything. We really don't. And I'm not saying I'm going to like the answer when I see it, but at least we're going to have an answer. And I don't think we're going to get anywhere with this. We're going to make ourselves feel better maybe, but it won't give us any data. They won't comply. They won't comply. And I don't, so this doesn't really get us anywhere. And that was my thought, Madam Co-Chair.
Further discussion from the committee? Representative Swanitzer?
Thanks, Madam Chairman. I don't think the policy of this committee can say they're not going to comply, so we shouldn't do something, and we don't have enough data to ask for data. So I don't really like the bill, actually, personally, but I do think it moves the ball down the field. I keep hearing other people say, well, this isn't enough, or this doesn't get us to where we want to be. So if it doesn't get us to where we want to be, bring something to the next meeting that we can talk about and work on to get to where we need to be. Can't just, we keep knocking down ideas without improving them, which is historically what the legislature does. So if this isn't it, can someone at least amend it to try to make it better or to ask or give it money? Maybe that'll do it, but it's a little tiring. Just, no, this isn't ready for prime time, but nobody's bringing anything better.
Senator Cost.
Thank you, Madam Chair. An idea I just am throwing out there, not making an amendment right now, but an idea. What if we were to say you have a year to become compliant and after a year, you will lose 3% of your funding or whatever from the state until this is met? I mean, what if?
Senator Kolb.
Thank you, Madam Co-Chair. Along those same lines, if we could possibly have an amendment ready to talk about in the next meeting that would address a possible set of penalties that could be picked from on noncompliance. And kind of leave it open-ended like that, so you could have time to draft up what you thought was workable and acceptable as for issues of compliance.
Drafting teeth. Representative Oakley.
Thank you, Madam Chair. I guess I'll just throw it out there amidst this discussion. I personally will not support any measure that takes needed and scarce resources from our local law enforcement that I work with very closely out there getting shot at and fighting and protecting our community every day, that we're then going to turn around and fine them, which takes it away from our own communities over, figuring out what we heard 18 crimes statewide were reported last year. Maybe there's some more, but I guess if I look at this like as an overview of what's important for our communities, we can find a way to get there. In fact, if we're going to mandate, for example, if Spillman's an issue, then rather than if we're going to mandate, then back it up with the money that they need to be able to work with Spillman and get it compliant. But I guess I can just throw it out there, just a personal opinion, but we start doing something that we're going to take away money from our city and our county law enforcement for this. And I certainly can't support it. I don't think that's in the best interest of our communities. My 2 cents.
Further discussion? Representative Yen.
Thank you, Madam Chair. So I agree with Senator Cole that, our role as legislators is oversight in many ways. So if for some reason our law enforcement is not obeying the law, we should do something about it. I don't know if the stick or the carrot is the best approach. I'm interested in hearing more of that, but I don't want to kill this bill just because we don't have the idea right now. So what I would do if there are no amendments, that I would say that we should come back at our next meeting and bring some amendments with some options, as Senator Cost noted, so we can make some of those policy decisions so we can exercise our oversight authority, because I think that's necessary. Otherwise, we will just have worthless statistics till the end of time and then never be able to make any policy decisions on worthless statistics. So,
Mr. Fuller, thoughts on timing for all of this?
Yep, Madam Chairman, I think the big question I would have, is this question of policy, this discussion of, what approaches should be prepared in advance of the meeting. I'm not sure, Madam Chairman, I'm in the best position. I'm not in the position really to make those choices. I've heard one option previously raised. If there are others, I'm happy to draft those. I'm not sure it's the best approach, though, to just, unilaterally come up with approaches for the committee to consider.
I would agree that that's concerning. And so I would discourage unilateral approaches to come to the committee at our last meeting. So committee, the conversation isn't over, so we'll call question here on this bill draft here in a moment, but the topic is still open. So if there's additional motions for a bill draft for the committee to vote on now for our next meeting, we can do that. Whether that be, reporting a financial penalty associated with failure to participate in NIBRs or something along those lines, or doing another type of topic associated with the hate crime piece, that's all on the table still. So those options are still available to you, but quickly you're running out of time. So with that, further discussion on the bill draft? Representative Rodriguez Williams.
Thank you, Madam Chairman. I stand strong with the comments from Representative Oakley and believe that we need to encourage further compliance for reporting in NIBRs before drafting any sort of penalty or attempting to defund the police. I look forward to the further comments from WASCOP, if they decide to follow up and encourage agencies to participate in the reporting.
So a couple issues right now, we're gonna do discussion on the bill draft currently, which does not have anything to do with funding or defunding or penalizing for failure to follow the law. So none of those pieces, it's just this bill draft in front of you. So any further discussion on 22 LSO 120 working draft point 4? Question being called, all those in favor say, and this is to sponsor it as a committee bill, so we'll do a roll call vote.
Senator Cooper. Senator French. Senator Kolb. Senator Cost.
No.
Representative Crago. Representative Larson. Representative Oakley.
No.
Representative Provenza.
Aye.
Representative Washit.
No.
Representative Rodriguez Williams. Representative Yin.
Aye.
Representative Zwanitzer. Co-Chairman Olson. Is that a
He
yes
said
or no?
no.
All right. And Chairman Nethercott.
No.
Madam Chairman, that fails with 2 ayes.
Thank you, Mr. Fuller. Further discussion on this topic? Senator Cooper.
I'd like to refer back to what Representative Oakley talked about. I can't support anything that's going to take away from our law enforcement. I'd rather see us task DCI with going to the non-compliant agencies and asking, what can we do to help? Instead of being the negative, let's try to be the positive in this and see how we can help them grow and do better. Thank you.
I think to respond appropriately and to bring it back to center. One is, what we heard is that the law enforcement agencies have had 6 years. 6 years of which DCI has provided training. You saw on the spreadsheet that one of the programs that they provided is a free training that they give and they provide and software that they have provided. So DCI, who has not statutorily authorized or has any authority over those agencies, is giving up their time as a statewide law enforcement agency to devote to local law enforcement in order for them to follow their statutory requirements as well. That is happening, and I believe that will continue to happen. I think the danger that you heard, and so I want to come back around, is it the police department's failure to follow with NIBRs going to actually cause their own defunding as a result of losing hundreds of thousands of dollars of DOJ money, which is a realistic concern. So whether or not their failure to get their act together in the last 6 years, whether we want to blame it on some source of funding or vendor issues, is it going to cause an actual reduction in resources for our law enforcement personnel? And the answer is, it could. And so it's important for us to pay close attention to that moving forward. There is no one here on this Joint Judiciary Committee, and let me reiterate, no one here that wants to defund the police. No one has alleged that, no one has asserted that, and no one is supporting that. Let me make that again abundantly clear, that that is not an effort. But there is a concern about a lack of compliance with the law by law enforcement, which will result in a loss of resources. We will pay close attention to this and continue to moving this ball forward. Is there any additional topic, any additional discussion on this topic before we move on to Wyoming Supreme Court opinions? Senator Kolb.
Yeah, thank you, Madam Co-Chair. I know my son is in law enforcement. My other son's in FBI. So it's kind of near and dear to my heart. This is an issue about laws and not following said laws that are on the books. It's simple as that. Now, whether approach we use, the carrot or the stick, I don't much care. But we got to have a conversation. We have to come together. We have to move this ball forward because we're not going anywhere without this conversation being answered. And I think it's high time we start prosing that conversation. Sounds like we're going to do it. I'm all in favor of it. Thank you.
Representative Oakley.
Madam Chair, I guess just one last comment. I just, again, I feel like it's a little bit of pushback. I think perhaps we're overstating. We're just now throwing out like this has just been this discussion with our counties and for 5 or 6 years, and it's just sort of been willful noncompliance. And what I'm hearing is that just we threw out there that this has been for 6 years. Perhaps this really was originally in 2015, as we heard some testimony. The feds didn't even have that fleshed out for another 3 years. I think just kind of us acting, taking it on as a, as the way it went. I think we might be rewriting history a little bit here, that like they're just not following the laws and we're just having this non-compliance issue. I think this is the first time we've discussed it. I'm not sure that the counties have heard all about it. I don't know. I guess we'll hear from them, but I'm not sure that this assumption that we're making that there's been willful non-compliance for 6 years is fair or accurate. So again, maybe if we revisit this, we can discuss that. I think maybe the counties and some law enforcement might give us some insight as far as that. So I'll leave it there.
Okay, with that, that topic is closed. Committee, we're going to take a brief 5-minute break. So come back at 4:25. All right, everyone, welcome back from the break. We've got some heavy lifting here before the day is through. Remember, we came back from a late lunch, so just a reminder of that, but we'll try to work through these pretty quickly. With that, we're going to start with 22 LSO 121 Working Draft Point 4, which is dissolution of county boards authority. We'll have Mr. Fuller walk us through the bill.
Yep, thank you, Madam Chairman. So this bill draft basically just clarifies that the boards of county commissioners have the authority to dissolve certain county created boards, and then it specifies the requirements for the dissolution of those boards. So moving on to page 2, this would be a new section in statute that provides a procedure for dissolving a board. And the language, I'll particularly note line 2 only references the boards that are created under Chapter 9, Article 1, which are the fairgrounds, pleasure grounds, airport parks. There's a staff comment later that highlights other boards, at least through our research, that that can be created by the county commissioners in statute. So the process, and this is based on kind of a combination of airport boards and county memorial hospitals, the only two entities for which there's specific language that provide for the dissolution of those entities. So first, this would be line 5, not later than 180 days before the proposed dissolution, the board must publish at least twice in the designated newspaper a plan to dissolve and terminate the board that's previously created. And then that plan must include at a minimum how the payment will be handled for all bonded and other indebtedness against the board, the disposition of assets, this is line 15, provided that any remaining funds would be expended or reverted as required by law. Then the next step, this is page 2, line 19, not later than 30 days before the proposed dissolution, the board must hold a public meeting and provide an opportunity for public comment, both at the meeting and also in writing. Moving on to page 3, after that public notice and comment has been completed, the board must either disapprove or approve by resolution the plan for dissolution and termination of the created board. Line 6 on page 3, if the Board of County Commissioners substantively amends the plan for dissolution and termination, they would be required to provide another opportunity for public comment and notice in accordance with paragraph 2, which is back on page 2. Page 3, line 13, upon approval and passage of a resolution that dissolves the created board, the created board must take all actions necessary to effectuate the plan for dissolution and dissolve and terminate the board, including the payment of all bonded and other indebtedness. And then page 3, line 20, not later than 90 days after the passage of the resolution dissolving that created board, that board must terminate its existence. Moving on to page 4, this is an amendment to existing statute, lines 10 to 13, just notes that the Board of County Commissioners has the authority to dissolve any board that's created under Chapter 9, Article 1, and then a renumbering. And then the staff comment, this is a list of the other, at least what I found in statute, where the Board of County Commissioners have the authority to create certain entities. So county law libraries, planning and zoning commissions, certain museums and solid waste disposal districts. And I think the question for the committee is whether those entities should be referenced in this bill draft in terms of a dissolution process. And then the final amendment to existing statute is to 189101, which is the provision where the Board of County Commissioners can create a board of trustees for fairgrounds or pleasure grounds or airport parks, and just makes clear that they can dissolve those boards that they create. With that, Madam Chairman, happy to answer questions.
Thank you, Mr. Fuller. And for the committee's reminder, this originates from a Supreme Court opinion recognizing that there was no dissolution provision in statute for a county fair board, and this bill draft attempts to solve that issue. So questions from the committee for Mr. Fuller? All right, seeing none. Looks like there's some folks at the table. Welcome, County Commissioners, and welcome specifically Laramie County Commissioners here at home. We have Laramie County Commissioner Troy Thompson and Laramie County Commissioner Gunnar Malm. Welcome to the Joint Judiciary Committee, and Mr. Riemann, always a pleasure to see you. Love to hear your thoughts.
Good afternoon, Madam Chairwoman, members of the committee. I am Jeremiah Raymond here on behalf of the Wyoming County Commissioners Association. Appreciate your time on this issue. My members are generally supportive of this particular bill. I will go through a few things as it relates to it and some possible amendments. First off, before I do that, I just wanted to note that under current state statute, commissioners in some circumstances have the ability to dissolve special districts. There is certainly a process in Title 22 for that particular process. Of course, the governor has the ability to dissolve boards that he establishes, and the legislature as well has that authority. But commissioners for the particular boards that are noted both in the bill for Title 18, as well as in the staff comment, the Board of County Commissioners may, in almost all of those instances, appoint these boards, but has no authority to actually dissolve them if they so desire. So from that perspective, again, we are supportive. Wanted to go through a few provisions in here and point out some potential opportunities to enhance the bill. First off, I do think that it is critical that we have the provision on page 2, which goes further through the bill that calls for a plan to be developed. And that's something that you generally see in those Title II dissolution statutes for special districts. It's important for a variety of reasons. You may have financial assets, property, whether that's land, equipment, et cetera. So we do need to take those things into consideration when we take these actions. The next comment that I wanted to make is relative to page 2, but it also reverberates in a few other provisions. In particular, if you look at page 2, line 5, it talks about not later than 180 days before the proposed dissolution, 180 days, 6 months, in order to take that provision. Perhaps you could read that and suggest that you have to take those 2 steps of publicly notifying within those 6 months. Maybe you could do that in 30 days, but 6 months is the timeline that's provided there. There are a couple of other timelines: 30 days of public comment, a second round of 30 days of public comment if you substantively change it, and then 90 days more before the resolution is actually in effect. So you could potentially be talking about a timeline that is in the 9 to 12 month range simply to dissolve a board. So that's something that I draw your attention to and suggest that for the 180 days that we perhaps should reduce that. And maybe if we're already going to dissolve a board and have potentially gone through 60 days of public comment, why do we need to wait another 90 days in order for it to actually come into effect? Madam Chairwoman, the next place that I want to go to is on page 2 as well, and that's in lines 15 through 17. It talks about dissolution or disposition of assets, but the rest of that language is focused on financial assets, and it really doesn't necessarily consider, again, those other property interests that may exist there as part of that plan. So I would suggest that maybe we need to broaden that provision. And it's possible that 22-29-407, which again deals with special district dissolution, might give us a framework for what that looks like. And it has those different classes of various properties. So we might look to bring that over into this particular provision. Chairman, I'm going to go to page 3 of the bill and lines 6 through 11. In particular, I'm going to point out the word substantively on line 7. And that word alone, I think, brings broad interpretations potentially of what substantively amending its proposed resolution would in fact mean. So I think we need to consider more thoughtfully what we would actually want to see in that particular provision. I do understand its intent. The other thought that I have is simply to strike this particular provision. The commissioners have already allowed for public comment, and like any other APA process would have to take that into consideration before they moved forward. So is it necessary? I'm not aware of any other state statute that requires 2 public comment periods to make government decisions. So again, perhaps it could be removed. Madam Chairwoman, the next place that I wanted to speak is quickly to the staff comment on page 4. I do think that these are boards that should be brought into the consideration under this particular bill. And I'll just point perhaps to a thought on a couple of them. Let's just assume that the Board of County Commissioners dissolves its zoning regulations within a particular county. Why should we be continue to be bound to have a planning and zoning commission in place if that's to happen? Is it likely? Perhaps not, but it is conceivable perhaps in some counties. The other one is a solid and waste disposal district. Perhaps that's a place where we've expended the resources within a particular county, and we need to, we no longer are disposing within the county and need to have that particular district, or perhaps we've found a private contractor that's now going to operate those facilities. Should we continue to be bound to have a solid and waste disposal district? I don't think so. With that, the one final comment that I would have is that I don't know that this bill hits on one particular point of the Supreme Court decision, and it's included in the memo that Mr. Fuller put together for you back in May, and that's the issue where a county dissolves a board for a matter in which you're required to act. So a county fair board is a great example where we have county fair boards, and those have to be under current statute operated through a board of trustees. So if you go to the Laramie County example, they attempted to establish a whole new department. The Supreme Court said that's not a board of trustees. And so simply taking this statute as proposed here, I don't know that it solves the issue that the commissioners were trying to attempt here, whether that's right or wrong. So with that, Madam Chairwoman, I would stand for questions. The commissioners are here so they can give you, if you have questions, a perspective from the ground of why this is important on occasion.
Commissioners, do you have any comments?
Madam Chair, I think more so in agreement with what Mr. Riemann said. I think here to answer questions specific to what happened in Laramie County, if there are those questions. So with that, I'll wait for questions.
Wonderful. Questions from the committee for Mr. Riemann, Representative Washit?
Thank you, Madam Chair. Mr. Riemann, you mentioned that under statute, commissioners already have the authority to dissolve a special district. Are the solid waste districts not considered special districts for that purpose?
Mr. Riemann?
Madam Chairwoman, Representative Washit, there are certain water and sewer districts and other special districts that could fall under those. These are specific under Title 18, in which the commissioners have the ability to establish those boards if they wanted to.
Further questions? Senator Kolb?
Thank you, Madam Co-Chair. In particular, I was supportive of this. I guess, how it gets drafted is how it gets drafted. But some of the time frame issues here with maybe being too long, I just want to share that there was conversation about giving everybody opportunity, giving all public comment, time. And you're right, I do agree that it could be shortened, but maybe, is it really that onerous, the extra time? I know the boards that we're talking about, and, they've been there typically for decades. So I think because they were here for decades, it seems kind of fair that you might have a more deliberative, longer process. And yes, the wheels of government are slow, but is that something that's a deal breaker for you? I thought, I don't know, that's the question. Next one is, yeah, this could be expanded to other boards, but I think this is the first stab at trying to deal with the Board of County Commissioners' authority to make and create, but not yet disillusionment, except for a few exceptions. So I think this is kind of a framework for future potential change in legislation that would expand it, from what we have on a framework. So I guess under those conditions, what do you still stand by and want to do the suggestions that you proposed? Or are we flexible with that? Would you oppose it if it didn't have that? Thank
Mr.
you.
Raymond?
Madam Chairwoman, Senator Kolb, are these deal breakers? No, but if I could just respond to each in turn, I think that might be helpful. One, I don't think you have any issue from us relative to public involvement and allowing for that. Let me just break it down a little bit, though, as it relates to each of these timeframes. The first 180 days is simply that we're providing notice. And so, that public notice could happen over, say, 45 days. We have to give 2 public notices in a newspaper. So I don't know that we need that 180 days. Perhaps you reduce that and you lengthen the 30 days that's in the first provision on page 2. Maybe you add that to 45 days or even go to 60 days, in order to provide for a longer period for public comment. The next 30 days is on page 3, and that's if we substantively amend. Again, this is a provision that's not as I understand, anywhere else in state statute or, sort of following APA that you would add a second comment period. So let's lengthen the first and get rid of this particular provision, perhaps. The last day or timeline provision is on page 3 as well, and that's 90 days after we've already made our decision, then we dissolve the board. Do we really need to have 90 days before we make that particular decision? I don't think so, but again, we could look at something different. Deal breakers, no. As it relates to the particular boards, I guess my response is, does it make sense for us to just say, here are 3 that you can create and dissolve, but we're not going to capture these others that you have the power to create, and we're going to keep them into perpetuity? So it's a policy decision. Deal breaker, no.
Follow up.
Follow up.
Well, it says specifically on page 3, line 20, no later than. So you could dissolve it immediately. It just has a maximum. So I understand what you mean. I just like to get something accomplished. How's that sound? Thank you.
Right, further questions? Representative Swanitzer.
Thanks, Madam Chairman. So you have a plan. Let's say you have a heavily indebted special district that's in trouble, it's going under, you want it dissolved. You have a plan to take on its liabilities and its debt. Does that just go against the county? You have a plan that it might take a year or 2, or you have to sell assets. In that time, the liability would just fall on the county commissioners and the county in general if they're underwater?
Mr. Raymond?
Madam Chairwoman, Representative Zwanitzer, was the question, should that then fall to the county to address that indebtedness? Is it?
Madam Chairman, I suppose in the plan, it would say what the best course of action is, but would it be the understanding that if it's when I see this process actually happening outside of the one instance in our county, it would be a problematic board that fraud, some kind of special circumstance to get rid of one of these special districts there would probably be some debt. Does the county just assume all of the liabilities until everything's squared away? Or have to put in the plan a specific who's taking the risk, I guess, is a question in a troubled special district that's going under your dissolving.
Great. Madam Chairwoman, Representatives Wanser, and I think that's why I point to those provisions in 22-29-407, because it, I think, better captures some of those circumstances. What happens if you have an excess of funds? How is that dealt with? Who then manages that within the county? How is it transferred back to the public, perhaps, depending on the particular situation, and also deals with those indebtedness provisions. So, there are, it's what, 5 paragraphs of language that's there that I think we might want to consider as part of this to better clarify who is responsible in that circumstance.
Right, further questions? Representative Craigo.
Thank you, Madam Chairman. Just going back to the 180-day provision, do you, as the county commissioners, have a recommendation of what you'd rather see that be? If it's not 180, is it 90? Is it 30? Is it 120? I mean, is there a sweet spot in there?
I think you're in the right, sorry, Madam Chairwoman, Representative Craigo, I think you're in the right ball frame for me. I was thinking in that 90 to 120 days, that takes off at least 2 months, maybe 3 months of the timeline there. Again, maybe it just takes some clarification to ensure that it's not more than, similar to what Senator Kolb was pointing out relative to the 90 days. Just a little unclear as you read that provision, what specifically you have to do in terms of waiting.
All right, further questions from the committee? So it is the county commissioner's position that this bill advance, is that correct?
Madam Chairwoman, that's correct.
All right, thank you both, all 3 of you. Sorry. Additional public comment on this bill? I don't think there is any. Anybody online? Nope. All right. Committee, public comment is closed. Back to you. Moved by Cost, seconded by Kolb. Amendments to the bill? Mr. Riemann, come back up. Representative Craigo?
My first proposed amendment, I would move that we change the 180 days on line 5, page 2 to 120 days.
So the motion is that on page 2, line 5, we change 180 days to 120 days.
Yes, Madam Chairman.
All right. A question being called. All those in favor, please say aye.
Aye.
Any opposed? Representative Craigo?
Madam Chairman, can I ask Mr. Fuller a quick question on the substantively language? Because I don't think we really got to that. Is that is that necessary language under WPA? I mean, WAPA, or is that mirror some procedure we have to follow under Administrative Procedure Act or not?
Yep, Madam Chairman, Representative Craigo, I'm unaware of any requirement. This was actually raised during our review process regarding this language. I'm unaware of any need, as far as I know, under the Administrative Procedure Act for this language.
And I lost where that is in the bill. Would you, it's that, I know what you're talking about.
Yeah, but Madam Chairman, that would be the language on page 3, lines 6 through 11.
Representative Craigo, you have a motion?
Yes, ma'am. Thank you, Madam Chairman. I would move that we delete lines 6 through 11 on page 3.
Seconded by Representative Oakley. All those in favor, please say aye.
Aye.
Any opposed? All right. Representative Craigo?
So, Madam Chairman, the last, well, there's actually 2 more requests, I believe, from the county commissioners, but the next one I'm a little bit more, I guess, confused by or troubled by, which is the disposition of assets. And if we go look at Wyoming statute regarding special districts and special district election laws, which is 22-29-407. We're talking about a little bit different situation there. And I don't know if we could do a conceptual amendment. But when we're talking special districts, we're talking about independent entities. And when we're talking about these boards, we're actually talking about county entities. A county fair board, for example, is part of the county, part and parcel. It's a subsidiary or ancillary arm in theory. The tax money that funds the boards flows through the commissioner's tax levy, comes out of the 12 mills. And so I don't know how to, conceptually, we could, between now and our next meeting, come up with some language. I just don't know if that exact language works because we're talking about independent entities versus, like I said, entities that are actually part of the county. So I don't know what that language should be, but I think we could come up with something, but I don't know exact language today.
Representative Craig, I think you've struck a chord because I think the counties feel like those entities are part of the county, but yet they don't have any control over them. Thus, they can't dissolve them. So it's this interesting hybrid. Thus, we're trying to solve that, right? But it's an interesting point that you make that really strikes to some of the issues that the opinion has created. So, Mr. Riemann, thoughts about that?
Yeah, Madam Chairwoman, Representative Crago, and I apologize that I wasn't clear here. I wasn't suggesting that we should just pull those over directly. I just think it provides a framework to address some of the issues that would exist in this situation. So I apologize, I didn't come with that particular amendment fully formulated, but I do think that it's an area where we have to, put together something in order to address the larger issues that are not just financially related, which this bill currently only focuses on.
Senator Cole?
Thank you, Madam Co-Chair. If I could put a little light on this, I think those assets are in fact owned by the Board of County Commissioners. All assets are owned by the Board of County Commissioners. They are managed by that board, to be clear. So the assets are in fact the Board of County Commissioners. That group, the trustees in some cases, has no authority to liquidate said assets. They have to have the Board of County Commissioners liquidate said assets. So they are in fact the Board of County Commissioners' assets because in a county form of government, the only owners of said assets in the county is in fact the Board of County Commissioners. If that helps clarify anything. Maybe I made more questions. Thank you, Madam Co-Chair.
Mr. Riemann, any comments?
Madam Chairwoman, I don't disagree with Senator Cole, but and I don't think he disagrees with me that we still have to have something here, particularly in that instance where you're dissolving a board because you're getting rid of, it's no longer needed for any purpose, and you need to get rid of assets or stop the mill levies and other things that are associated with that.
Any further, Representative Yen?
Thank you, Madam Chair. So, I guess I have a question on how that would apply to contracts. Is the county's name on all contracts that a special districts board undertakes, or is it the special district that engages in a contract with a third party? And I'll continue with that question if there's a good answer for that.
Madam Chairwoman, I'd have to defer to one of my former commissioners or the commissioners in the back of the room, but I do want to make clear, we're not talking about special districts here. We're talking about boards that the county has established.
Commissioner Malm, welcome back.
Madam Chair.
Thank you, Madam Chair. Just briefly, this kind of was the genesis of what led to the dissolution of Laramie County Fair Board here, was that they entered into their own contracts and were executing contracts on their behalf. And so to kind of play the tape forward in that scenario and along the lines of what's proposed in the bill with having a plan, while we were litigating this issue, the county commissioners took that money that had been in the Fair Board's account that was drawn on that mill levy. And we set it aside and waited for the disposition of the whole case. And ultimately, I don't believe the Supreme Court adjudicated the money piece, nor did Judge Campbell when it went back to district court. And so we just made the decision as part of our plan that those funds would go towards the operation and maintenance of Laramie County Fair in perpetuity until they were gone. But they did, up until their dissolution, enter into contracts based as Laramie County Fair Board, not as the county commissioners.
Representative Yan, follow up.
Yeah, thank you, Madam Chair. So I think when it comes to Representative Zanis's question about indebtedness, transfer of contracts really makes sense to ensure that it goes to the county, not that they plan to do it and then they'll take public comment. And if they don't plan to do it, then what happens to it? So in Wyoming statute, I'll point to the committee 11-16-117. It talks about the dissolution of a conservation district. And in 117D, it actually has the language for all contracts to which the district or supervisors or parties remain in force and effect, and the commission is substituted for the district or supervisors as part of the contract. So that sounds like language that we should be putting in this, Madam Chair.
Senator Cole.
Thank you, Madam Co-Chair. Yeah, to be clear about Conservation District, it's on a separately elected board. The issue with indebtedness with a county and a county subsidiary, or, a fair board, let's say, we're talking about currently. They are not allowed to indebt the facility by signing a contract because they don't in fact own anything. They manage the facility, so they can't indebt the facility. It's pretty clear. So that all goes back to ownership of the property and who has control of the property as the owners, but not the managers. So in fact, if they entered into a contract with someone else without having the Board of County Commissioners agree to said contract, then that would be an issue. The same thing goes with hospital indebtedness. If you're a county memorial hospital, same exact rules apply. But sometimes it's confusing because there's districts and there's county memorial hospitals and there's different entities. But to be clear, it goes back to the ownership of the property, and they can't sign a contract for debt. They can't even supposed to get a tax anticipation loan without Board of County Commissioner approval. And it varies with counties, but statutorily, from what I've learned from our learned attorneys, as being a county commissioner, that is what they've told us. And it is written in statute. If you read them carefully about the ownership of said properties, it all goes back to the Board of County Commissioners. So I think it's covered. In fact, the debt that they would have to resolve was a debt they had to have agreed to, that being the Board of County Commissioners. If that, I don't know if I answered questions, but I'm trying. Thank you, Madam Co-Chair.
Thank you, Senator Cole. Further discussion? Comments? Mr. Mom, Mr. Raymond, no? Okay, Representative Crago, any further amendments? We want to encapsulate some of those staff comments there about solid waste disposal districts or planning and zoning commissions.
Madam Chairman, I do. County law libraries, I don't know if we really need to deal with that. I don't even know if any exist anymore. Oh, of course you guys have one.
They do? Yeah, Senator Cole?
This is a very interesting conversation. So now we're getting into the judge's world, the district court judge in particular, and they are in love with Western law. What is that? There's a set of books they like to have for some reason that can't be accessed electronically. So we, in fact, in Sweetwater County do have a county law library. It's been moved because there was a reason for it back in the day, but it's been antiquated. And it's really, if that's an available situation to get rid of, that would be probably appropriate. I think I can tell you, I have never seen anybody I was commissioner for 8 years. I never watched a person go down to the library if it helps out, at least in Sweetwater County. And then the waste disposal districts, yeah, that's a wholly appointed board. In the case of Sweetwater, I can say this. So I think any board that's wholly appointed by the Board of County Commissioners, they should in fact have the authority to dissolve. Maybe a simple way of saying it. Thank you, Madam Co-Chair.
Thank you, Senator Kolb. Senator French, comments about your county law library? So this is what the statute says about that, just for your curiosity in 53111. The Board of County Commissioners shall have the power to establish and maintain in their respective counties a county law library for the use and benefit of the judge of the district court and other citizens of the state, and shall have the power to appropriate and set aside for the maintenance and support of said library such monies as it shall deem necessary or see fit.
I do.
Representative Crago.
So here's my amendment, my proposed amendment, Madam Chairman.
All right, let's hear it.
My proposed amendment would be to add all the entities, the county entities in chapter 10, as well as solid waste disposal districts, which is chapter 11, 1810 and 1811. And the reason I'm not including planning and zoning commissions is I think there's some stuff out there that, yes, you could get rid of zoning, but you can't get rid of subdivision laws, and the planning and zoning commission still handles subdivisions in all the counties. And I don't know what the ramifications are of that. And so I guess I'd have to think about that one a little bit more before I'd be willing to bring that motion. But the other two entities or groups of entities I'd like to add into the bill.
Moved by Crago, seconded by Representative Yen. Any discussion? All those in favor, please say aye. Aye. Any opposed? That motion has passed. Any further amendments to the bill? Mr. Reman,
Just, Madam Co-Chair, just a clarification. Did we vote on striking on page 3, the amendment, striking line 6 through 11?
we did. We struck it. Yep. Mr. Reman, do you have a preference? Is there any additional work you think that the committee should do on the bill before taking this to the session? Or would you feel confident for the committee to sponsor the bill now? Would you like another interim meeting to work it? Because we have one more meeting left. Not sure what your preference might be.
Madam Chairwoman, I'm perfectly fine if we want to move this forward as you've amended it here, with the caveat that you should expect that I'll continue to work on that disposition portion of this, and I'll look across the various statutes and try and bring something to your attention in the legislative session.
And so committee, there's that kind of outstanding issue for us to take a look at so we can try to address it at our next meeting or in session. So it's kind of the committee's pleasure for whether or not you'd want to. So the next motion should be either to move to sponsor the bill or move it to our next meeting. Representative Washit.
I would move that we bring the bill to the next meeting. I prefer to have legislation as close to perfect as the committee can make it before we take it to the body. And so let's get this thing done with all the dissolution language and everything at our next meeting.
Seconded by Senator Cost. Any discussion? Question having been called, all those in favor of moving this bill draft to our agenda for our next meeting, please say aye. Aye. Any opposed? All right, that motion has passed. All right, thank you all so much. Appreciate seeing you. Okay, with that committee, we have a couple of summaries to go through on Supreme Court opinions. So Mr. Fuller. And is there anyone intending to provide public comment on any of these three cases? No? Okay. And is there anyone online, do you know, that is intending to? Okay, great. So that we'll just take them in the order that they're listed then. Mr. Fuller, if you want to start with Romine.
Yep. So Madam Chairman, members of the committee, excuse me, this case concerns the Wyoming Governmental Claims Act, which generally grants immunity to governmental entities and its public employees who are acting within the scope of its duties from liability for any tort, except as this act otherwise specifies. And the issue here is whether a statute that waives governmental immunity for the negligence of healthcare providers who are employees of a governmental entity applies only to medical malpractice claims or to claims of ordinary negligence. And there are two provisions that are at issue here. First is 139-109A, and this is in the summary. A governmental entity is liable for damages that results from bodily injury or wrongful death or property damage caused by the negligence of public employees while acting within the scope of their duties in the operation of any public hospital or in providing public outpatient health care. Then 139-110A states that a governmental entity is liable for damages resulting from the same caused by the negligence of healthcare providers who are employees of the governmental entity. And the reason this came into play in this case is that next subsection, 139-110B, limits the liability of a governmental entity to $1 million to any claimant for any number of claims arising out of a single transaction or occurrence. And this is an exception because generally under the Governmental Claims Act, the maximum liability is $250,000 to any claimant. So whether that section 110 applies means a different financial liability limit for the state. What happened in this case is a certified nursing assistant at the state hospital, hearkening back to this morning, sexually assaulted a woman who was involuntarily hospitalized under Title 25. And she was assaulted on numerous occasions, and the woman's conservator sued the state hospital under both 109, which deals with just public employees, and 110, which deals with healthcare providers. The state hospital moved for summary judgment and argued that the woman's complaint, since it sounded in ordinary negligence, 110, which is the section for healthcare providers, didn't apply. And that section instead concerns only medical malpractice claims. And the district court disagreed. And the state hospital appealed or sought a writ of review, which is kind of a separate issue in the case. But the state hospital argued that under 110A, the state has immunity from liability when a plaintiff only asserts ordinary negligence. Or put another way, the state hospital argued that the waiver under 110A applies only to claims of medical malpractice, which was not the plaintiff's claim in this case. And in support of that argument, the state hospital pointed to the use of the word negligence in both 109 and 110, that if 110 also applied to negligence, that would render 109 basically duplicative or superfluous. The Supreme Court concluded that while the two statutes may overlap, each applies to different actors. So 109 applying to all public employees and 110, which covers healthcare providers. And the court also noted in its previous recognition in other cases where the provisions can overlap. So one of the examples the court cited was a 1986 case where a law enforcement officer operated a motor vehicle, which can fall under Section 105, which deals with negligence of public employees operating a motor vehicle, and 112, which applies specifically to law enforcement officers. And so in this case, the court noted that since that 1986 case, the legislature hasn't acted to eliminate any potential overlap of immunity waivers in the Governmental Claims Act. So the ultimate conclusion for the court was the plaintiff could bring her claim under 110, triggering the higher financial limit. And I think the considerations here for the committee would be whether any legislative change is necessary to address those similarities or overlap, or whether there's any change that may be needed to clarify or amend the scope of the state's liability for claims involving injuries that are caused by the negligence of healthcare providers who are employees of a governmental entity. And Madam Chairman, with that, I'll stand for questions, but I'd also note, just by way of background, these cases, kind of from the last meeting, these cases were identified by the chairman and generally involve either an explicit invitation from the court for the legislature to consider some sort of statutory change, or interpret a statute where they've noted either some sort of legislation action or inaction.
Thank you, Mr. Fuller. So what I'd like to do, because the hour is late and I sense we're going to lose people, is there anyone that is intending to leave the meeting? I know we've lost 2 representatives. Please check with your chairmans before you do leave, so we can initial your forms correctly. So anyone else intending to leave, please raise your hand so we can plan the meeting accordingly and make sure we have a quorum. Okay, anyone else? All right. I understand that we need to leave. We also have to do the people's work here. So you can leave. So the issue for this case is, just to kind of help summarize us and get us to where we need to go, is whether or not really the committee wants to clarify that 139, 110 B really, which one?
Madam Chairman.
A, right, what is regarding medical malpractice as opposed to just general negligence of public employees. It's my position that that's the appropriate interpretation of the statute and how the court should have decided. Further comments from the committee about that? Representative Craigo, agree, disagree?
I agree.
So perhaps a bill draft might be required in order to reflect maybe some proposed statutory changes to provide clarification to the statute. So the court doesn't allow for a medical provider who commits an assault, right? That rape is not medical malpractice. Right? So that's what we can really make a distinguishing concept there. Yes. Can I get a motion for that potentially? Do you need some help? Mr. Fuller, the committee would like, Mr. Representative Craigo would like a motion to clarify 139, 110 to provide claims only for medical malpractice related claims associated with healthcare providers and not general negligence. I second that motion. Further discussion from the committee? Question being called. All those in favor, please say aye. Any opposed? All right, we'll have that bill draft at our next meeting. All right, Mr. Fuller, recognizing too at our next meeting, we just disposed of an entire topic today that has consumed about a half a day of the committee's time. So we will not have that at our next meeting. So I'm hopeful we can get through some of this work that the Supreme Court has identified needs some maybe legislative eyes on it. So I do think it's important, and I know we're getting late into the hour, but recognizing we'll have some time at our next meeting and that these are issues identified by the judicial branch as potentially needing some legislative review. So Mr. Fuller, if you would like to go into In Re Triple AE.
Madam Chairman, members of the committee, this case concerns whether a court has discretion to deny a petition to establish paternity after the court orders genetic testing and after the results of that testing establish the paternity of a man for a child. So just a few background points. Under current statute, a man is presumed to be the father of a child if he and the mother are married and the child is born during the marriage. When a child has a presumed father, statute limits the time for filing a paternity proceeding to within, and the statute uses the term a reasonable time after obtaining knowledge of relevant facts, but before 5 years after the child's birth. A man whose paternity is to be adjudicated can maintain a proceeding to adjudicate the parentage of a child, and a party seeking to adjudicate parentage can ask for a court to order for genetic testing if the party alleges paternity and states facts that show a reasonable probability of the requisite sexual contact between the individuals. If the court denies genetic testing, then the court must issue an order adjudicating the presumed father to be the father. If genetic testing is ordered and the man being tested has at least a 99% probability of paternity and a combined index of that testing of at least 100 to 1, then the court must adjudicate that man who was tested as the father. And then finally, statute provides that the paternity of a child with a presumed father can be disproved only by admissible results of genetic testing that it either exclude the presumed father as a father or identifies another man as a father. So in this case, and I'll use initials for clarity, but FCM was married to JCM, and FCM had a romantic relationship with TE, and AE was born while FCM and JCM were married. So basically what happened is, so you have JCM is the presumed father, and TE ultimately turns out to be the father. And TE took a paternity test, and those results showed a 99.99% probability, but TE took no action to establish paternity. About 2 years later, the Department of Family Services took protective custody of AE of the child and sought to terminate the parental rights of AE's parents, who were FCM and JCM, the presumed father. They both voluntarily relinquished their rights, but TE, the man believed to be the father, responded and argued that DFS, the department, couldn't terminate his rights because he didn't have any that were established. At the same time, TE filed a petition to establish paternity and moved for an order for genetic testing. The department objected, arguing that TE did not bring that paternity action in a reasonable time. The district court granted the motion for genetic testing, and it revealed that the probability was 99.99% and a paternity index of, I think, more than 1 billion to 1. So pretty much establishing TE as the father. And the district court initially granted TE's motion to adjudicate him as the father, but it later vacated that order and held a trial. And then after that trial concluded that TE failed to file his petition for establishing paternity in a reasonable time. And the Supreme Court, TE appealed and the Supreme Court reversed, relying on 14.2.8.17, which provides rules that a court must apply when adjudicating the paternity of a child. And because the district court had ordered genetic testing and that testing revealed that TE was the father under statute, the Parentage Act required the district court to adjudicate TE as the father. And there was no discretion for the district court to consider the question of timeliness after it had ordered the genetic testing. And the Supreme Court made that clear in its holding, that the district court has discretion to determine that question of whether a person timely filed a petition for paternity and genetic testing before ordering the genetic testing. But once the district court orders genetic testing, that timeliness issue cannot be considered if, particularly after, that person has been found to be the father under statute after that genetic testing. So I think really the issue here for the committee to consider is whether a court can or cannot deny a paternity petition after ordering genetic testing for some other reason. Here, it would be timeliness. With that, Madam Chairman, committee members, I'll stand for questions.
Thank you, Mr. Fuller. Senator Cole.
Oh, thank you, Madam Co-Chair. That was an interesting alphabet story there. In so much as, so the question, if I understand it right, is once the court orders genetic testing, do they have to then abide by the said results of the genetic testing?
Mr. Fuller.
Yeah, Madam Chairman, Senator Kolb, that's essentially the question is, once the court orders genetic testing, can the court then basically go back and say, you didn't file your petition in a reasonable time? As the language is used in the statute. That would be the question, whether the district court can go back and address that timeliness issue later after the genetic testing, or if, as the court held, it can only do so before ordering the genetic testing.
I understand. Thank you.
Further questions for Mr. Fuller? Contemplating the alphabets. Senator Kolb.
I won't get involved with the alphabets, Madam Co-Chair. I would move, or I would like to have a bill draft drawn up that would address that issue about once a judge orders genetic testing, that the results of said genetic testing had to be adhered to, as if it came to be the father out of that result, then that would then be so deemed the father.
And
there was a motion, a couple of things. Everyone, we are getting tired. It is warm in here too, which doesn't help. Get close to your mics. Senator Kolb did present a motion which was in essence that if a court orders genetic testing and that genetic testing reveals that an individual is a parent of a child, that information can be used as opposed to statutorily barred, in essence, is what the motion was. And Senator Cost seconded that motion. So I think now we're discussing the motion. Co-Chairman Olson, I think you had some thoughts, and so does Mr. Fuller potentially.
Yeah, I can see Mr. Fuller's wanting to comment, but I was just thinking, just listening to Mr. Fuller in his summary, one option is to solve that solution appears to, because the holding was very clear in this case, would be just codifying that holding. That's one option, which is it's Mr. Fuller's recommendation, number one, make clear that a court cannot deny a paternity action after ordering genetic testing that meets statutory threshold. That's codification of the holding opinion. But then number two, I just want to make sure, Senator Kolb, you have that option in front of you, which is to amend the Parentage Act to allow a district court to determine the timeliness of a paternity petition at any time before or after ordering genetic testing. So I'm just trying to clarify which of the two options Mr. Fuller presented that you would like to proceed with. That was really all I wanted. I don't have a preference.
Senator Kolb?
The first one. I think what the results are the results. And, I understand there's a timing issue, in statute, but the facts are the facts that we're living with in this age about genetic testing. And I think it has relevance to use those facts as are discovered, whether we like the results or not. So the first choice out of the two.
Representative Craigo?
Madam Chairman, just for discussion purposes here, I think in this particular case, the Supreme Court was looking at the first part of the statute that talks about reasonableness within a reasonable time. We're not talking about the 5-year time limit. And I think those are two different things that we really need to flesh out a little bit, because the purpose of the 5-year time limit is to create certainty, right, in a child's life, so that the child's 17 and somebody comes and says, oh, by the way, I'm your dad. And I think that has some ramifications versus the part about within a reasonable time, which is what the Supreme Court was getting into here, because in this case, the person knew he was the father, but waited 3 years to come forward and with the petition to establish that. Still within the 5 years, but the argument from DFS, I assume, was, hey, that's not reasonable. You knew a long time ago you were the father, you've known all along, and now you're going to show up. And so I guess I'm a little bit worried about that particular language, because that would take us outside of potentially outside of the 5-year limit, which I don't think we should do. And so I don't know how to work that out, but just sitting here, that's one of my thoughts is, how do we deal with that? And maybe Mr. Fuller has an idea that we could deal with that problem. And then the language, and I think Mr. Fuller would obviously get this done, but the language make clear that a court cannot deny a paternity petition after ordering genetic testing that meets the statutory thresholds. I think it should be on, and maybe we just use that language on the basis of the fact it wasn't applied within a reasonable time or something. Somewhere in that, I would address that, because we need to make clear that it still has to meet some sort of statutory timeline, the 5 years or whatever. But that's just for discussion.
Co-Chairman Olson?
And maybe Mr. Fuller can clarify this, but so it all hinges on whether the district court actually issues the order for genetic testing. So the court has a lot of discretion in that regard, whether they were looking at a 5-year period or whatever period. They could. So my question is, under what circumstances, I guess, they could deny the genetic testing order, the order for genetic testing. Because if they do that, then the second condition doesn't apply, which is what we're mandating.
Mr. Fuller?
Madam Chairman, Chairman Olson, I think the way that language is in that section regarding the timing for filing that petition to adjudicate parentage I think it says, in no event, can one be filed after 5 years. And I think a court, I certainly don't want to speak for a court, but, that's pretty clear language direction for a court to follow if someone tries to file a petition and it's been after 5 years of the child's birth. In terms of, maybe to bring it back for the committee, if it's the committee's intent to codify this holding, then it may just be as simple as a sentence or two in the relevant section, which I'll find and include, to say that, a court, shall not consider, the reasonableness of, or shall not consider whether the petition was filed within a reasonable time after issuing an order for genetic testing. And it may just be as straightforward as that. It wouldn't touch or address or change the existing law that says in no event shall a petition be filed after the 5-year mark.
Senator Cost?
Thank you, Madam Chair. My question would be, what's the determination of reasonable? Is reasonable the same in all courts, or do we need to make it more specific than that?
Representative Craigo?
I wish I knew what reasonable was. It depends on the situation. I mean, I think that's, obviously in this case, that was the one argument was, and I'm assuming DFS argued, look, you knew when the child was born, it was yours. So to wait 3 years was not reasonable. You may have another situation where somebody, and this happens, somebody notifies the father 3 years later, 4 years later, and as soon as he knows, he goes and files a petition. Well, 3 years there was reasonable. It wasn't reasonable when the person, or in theory, it's an argument, wasn't reasonable when the person knew the day the child was born. And so I think we leave that to the judge, and we don't try to define that, and we let the judges handle that. They're in the best position. They'll know the individual facts of each individual case.
Senator Cole?
Thank you, Madam Coach. He obviously didn't know he was the father. So I'll just take that as a point of, as a hypothetical. I think if we leave the deference to the judge and we just say, if you order a test because you've decided that was a reasonable thing to do at that point, I think that's a good way to leave it. In a way to fix this in a way, and we can readdress it, I suppose, in the future, but I think this goes a long way in clarifying this question that we're reviewing. Thank you, Madam Co-Chair.
Further discussion from the committee? Question on the motion? And committee, remember, we don't need to take action on these, but it's important, I think, for us to review them and understand if it does need legislative review. So there is a motion on the floor for Co-Chairman Olson would like to add to the discussion.
Yeah, sorry, I just want to add a piece to the discussion. And it was probably what caused my confusion in my response to Representative Craigo, which was, I guess I don't know this is probably a pretty rare circumstance in the way that the order for genetic testing was ordered, because this is contemplating an order for genetic testing somehow takes place in some other action, right? And then a paternity case is later brought. I don't know how common that is as compared to a paternity case being initiated and the genetic testing order comes inside of that paternity case, because that's a pretty common scenario where a man will, or either party will petition the court, and immediately that's your first motion is for genetic testing. So to Chairman Nethercott's point, I don't know whether we need to take action on it. I guess that would be what I would be curious about, is just how rare of a circumstance is it because the order was issued inside of the DFS case.
Mhm.
And so I don't know how common that is. I doubt, Mr. Fuller, you have the answer. I don't know.
Representative Washit.
Thank you, Madam Chair. So the alternative is if we don't pass this motion, then the case law stands, the ruling of the court becomes a precedent for similar matters should they occur in the future, and we move on without taking any legislative action. Is that accurate?
Correct. Representative Yen?
Madam Chair, so this case is, I mean, I think Representative Olson is correct, co-chair is correct, that it's probably a very rare occurrence. But in this situation, TE knew he was the father basically the moment he was born because he purchased an at-home paternity test, but then didn't decide to establish parentage. And then try to establish parentage after a DFS case was brought to bear. So, you know, I don't know if that really makes sense for the timeliness argument to allow parentage rights for TE. So when it comes to the policy decision, I'm probably against codifying what we have in this case, but I'll vote for a bill draft just so we can have that discussion on what is or is not the right policy case. And it'd be great if that bill draft came, if DFS came to talk to us about it. So thank you, Madam Chair.
Okay. Okay, question having been called. All those in favor, please say aye.
Aye.
Any opposed? All right, that motion has passed. All right, and so the last one for our consideration, which we'll move through, this is also kind of technically tricky, I can tell you, is Harrison v. State. Mr. Fuller?
Yeah, Madam Chairman, members of the committee, the question in this case is whether a person is relieved from the duty to register as a sex offender for a certain period of time when he wasn't required to register for a portion of that time after his initial conviction. And here's the background. The legislature enacted the Wyoming Sex Offender Registry Act in 1994. And it requires generally offenders who are convicted of certain sexual related offenses or offenses against minors to register, and in doing so must provide certain information to the sheriff in the county where the offender resides, attends school, or is employed. Originally, the act required offenders whose victims were less than 16 and the offender was at least 4 years older to register. But in 2007, the legislature amended the act to require a person convicted of certain sex-related offenses to register regardless of the victim's age. And the duty to register under current statute begins on the date of sentencing and requires a person to continue registering for the rest of the person's life. But certain offenders who have been registered for at least 25 years, exclusive of periods of confinement and periods in which the offender was not registered as required by law, can seek relief from the registration requirement so long as the offender has met a number of requirements, including keeping a clean record for that 25 years. And then statute allows the district court discretion to order the offender relieved of that duty to continue with the registration requirement. So the offender in this case was convicted in 1994 of what at the time was 4th-degree sexual assault. And this was repealed in 1997 and replaced with what is currently 3rd-degree sexual assault. The victim was older than 16. So upon conviction, the offender was not required to register as a sex offender. But after the legislature's amendment in 2007, he was required to register and began registering in 2009. So in 2019, 25 years after his conviction, the offender petitioned the district court to be relieved of that duty to register. The district court initially granted it, but the Division of Criminal Investigation intervened and moved to have the order vacated, arguing that because the statute requires registration for 25 years, and here the offender only registered for 10, he didn't qualify for relief from the registration requirement. And this time after that argument, the district court agreed. The offender appealed, the Supreme Court affirmed and held that the statute for purposes of relief applies to an offender who has been registered for at least 25 years. And specifically for the committee here, the court noted that that statute 719-304A did not say and doesn't say anything about including periods where an offender wasn't required to register as counting towards that 25 years. And the court won't read words into the statute that aren't present. And so here, the court held that the offender had to actually register for 25 years before seeking relief from that registration requirement. And the consideration here, I guess recognizing perhaps the uniqueness of this case, the facts, given the date of conviction and the change in registration requirements, the consideration for the committee would be whether statute should specify how periods of time where a person was not required under law to register should count towards the minimum time of registration for seeking relief, and if so, whether there should be other requirements associated with that counting of that time.
Representative Oakley.
Madam Chair, thank you. I'll pose this as a question to Mr. Fuller. Would there be a way, rather than messing around with what counts as periods of time that they registered and didn't register, would a fix be just to say from the date of conviction? I mean, clarifying in that way.
An option. Mr. Fuller.
Madam Chairman, Representative Oakley, I'm not sure I fully understand the question. So the question would just be to say you have to register from the date of conviction, which I think statute currently requires that. The once upon conviction, you have to register exclusive, and then that 25 years, that there is language in there that says exclusive of confinement. And so if the question is just you can petition for relief 25 years after the date of conviction, I mean, that's certainly a policy matter for the committee, if I understood the question correctly.
Representative Oakley.
Thank you, Madam Chair. I think so. I guess I was just, if the clock started, if we use date of conviction, and it seems like it wouldn't be this calculation of, and maybe I see what you're saying, like after they're released from incarceration.
So
that's what this, is that what this hits?
Mr. Fuller.
Madam Chairman, Representative Oakley, I'm not sure it exactly hits that. I think the discrete question here is you have an offender who was convicted of a sexual assault who was not required to register because at the time the Sex Offender Registry Act didn't apply to that particular offense. That was later changed and made retroactively applicable to that person, to where now that person did have a requirement to register, did so for 10 years, and then 25 years after conviction sought relief, even though he had only been registered for 10 years rather than what the statute says in terms of 25 years.
Senator Kolb.
Thank you, Madam Co-Chair. So it's clearly just about time where you weren't required to be registered, counting in that 25-year block of time
Right.
to seek relief.
Right.
Madam Chairman, Senator Kolb, that's the question for the committee.
Well, yeah, I'm
That's the question.
fine with it. I'll move that we have a bill draft drawn up to that purpose. I would state those needed changes in the statute where time when you weren't required to be registered would count towards the 25 years, barring any of the other requirements, like incarceration or whatever, would not count. So anytime that you served without registering from your offense, that non-required time to be registered. I went around in circles here. I guess I'm getting tired. That would be included. It was if you weren't required to register, how can you hold that against somebody at that time, at a later time, if you weren't required to be registered, yet you served that period of time without another offense?
seconded by Senator Cost. Discussion, Representative Craigo? Oh, I'm sorry. I'm sorry. Ms. Chambers, yes. You have to.
Thank you, Kara Chambers, Attorney General's Office. It's sort of ancillary to this topic, but the Attorney General asked that I request this of you. So DCI, it is related to the Harrison case, has had issues where courts have ordered termination of registry for certain offenders that are not necessarily in compliance with the act. And of course, DCI, as the administering agency of this, is kind of caught off guard, not provided notice of these orders, and again, just makes it very hard for DCI to administer the sex offender registry list. So in your discussion on addressing these sort of issues, we could perhaps provide some language that would require DCI to be served when these orders go through. I mean, it's probably just a simple change to 719-304A3 so that we can participate in the process to be clear about these
Senator Cole, would you like that to
circumstances.
be part of your motion?
Yes.
All right. And Senator Cost, you find that friendly. And so, Mr. Fuller, do you understand?
Yep, Madam Chairman, I understand that part. I just want to make sure I'm clear on Senator Cole's motion because
Yes.
current statute. So we're only saying that if a person was not required to register under law, that time would count. And I want to make clear that it's not, because right now, periods of confinement do not count toward the 25 years. I just want to make clear we're not changing that.
Correct.
We are not changing.
Okay, thank you.
Further discussion? All right, seeing none, all those in favor, please say aye. Any opposed? All right, committee. Excellent work today. We powered through. Let's do a quick summation of our directions to Mr. Fuller. Let's give him a minute to breathe here for a second. Oh, any final public comment? There's somebody, the director. I can't see. Any other public comment online? Nope. All right. We will start wrapping up this meeting. Give Mr. Fuller a minute or two to put together. Nope, he's ready to go.
Ready when you are.
All right, we are
Okay,
ready.
So I'll just run through the committee's actions. So the committee voted to sponsor 22 LSO 117, which would be for 3 new district judges, to sponsor 22 LSO 115, which was the resolution for amending the Constitution for judicial retirement for Supreme Court justices and district judges. A new bill draft for pre-application determinations for purposes of licensing. The committee will carry forward the juvenile data reporting with revisions, a bill draft concerning delinquency placement criteria that was provided by Ms. Sheen. 22 LSO 118, the restraint of trade, that will continue to the next meeting with changes. A new bill draft for non-compete based on Colorado's law. 22 LSO 122. So for Title 25, that bill draft for 112 will be brought forward to the next meeting with the changes from Ms. Reed's final version incorporated in that draft. Then there will be a second bill draft that will be virtually identical to that one, except for the changes in the language regarding costs as previously discussed. Then there will be another bill draft that would independently amend 2510-112 to just change the cost provision based on what was discussed, but change only those provisions as they exist. And then there will be also an amendment to the bill that wouldn't change, that would just remove costs altogether. Then 22 LSO 121, the dissolution for county boards, that will carry forward. And then a bill draft for each of the 3 cases that was just discussed previously. The committee took no action on the workload studies bill draft, and the committee failed to sponsor discrimination prohibition amendments 22 LSO 119 and bias motivated crime reporting 22 LSO 120.